Committee Room 30. Signed. 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 Committee Room 30. Committee Room 30, signed. 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 Committee Room 30, sound. Committee Room 30, sound.
Go ahead. So the meeting is now live, and I want to welcome everyone to the 58th meeting of the Committee for Justice, and I am stepping in to chair today's meeting as Paul, the chair, is sick. So I want to advise members the committee meeting will be recorded and broadcast throughout Parliament buildings and online, and that everyone here is welcome to use their mobile devices as long as they're in airplane mode and are muted. We're going to have oral evidence sessions today with the Department of Justice officials on both the December monitoring round and the Justice Bill recorded by Hansard, if everyone is content with that. Yeah. And can members be reminded that they're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matter under consideration. So anybody that wants to declare an interest, they're open to do so now or when that particular matter arises.
Chair, can I declare I have an immediate family member works for the probation board?
My galore, Danny. Ciara?
Just a member of the All-Party Group for Access to Justice.
No problem. Brian?
There's correspondence there from the Committee for Finance, which I'm a member.
Lucky you. So then our first agenda item is apologies, and we have apologies today, as aforementioned, from Paul Frew, the chair of this committee. Any other apologies? Brian?
Yes, from Morris Bradley.
Happy to note that. And we also have Danny Baker and Doug Beattie attending the meeting online. You can both see and hear us.
Yes, can do.
Thank you, Doug. And I know Danny already spoke to us. So the draft minutes of the meeting held last Thursday, the 4th of December, are at pages 5 to 12 of the meeting pack. Is everybody content that these minutes are a true reflection of the proceedings of the meeting last week?
Yeah.
Right.
Yeah.
We're happy to sign them then. Happy days. And then we have our third agenda item, which is matters arising. So, Law Society, can people go to page 4 of the table pack for the relevant papers? So we had a request from the Law Society for copies of the papers provided by the Department on the plans to undertake 2 engagement processes on options for legal aid reform, which were considered at the meeting of 27th of November, and for the papers for the enabling access to justice papers from the meeting on the 27th of November. I want to remind members that the committee considered and agreed to a similar request from the Bar at last week's meeting. Is everyone content that we forward these requested papers to the Law Society?
Yeah.
Yeah, happy days. We can action that. Does anyone else have any other matters arising from the minutes? No, everyone's happy enough. Okay, so today we've got Department of Justice officials. Our first, I suppose, substantive agenda item is an update on the December monitoring round, and we're getting real evidence from Department of Justice officials. You'll find relevant papers at 14 to 76 of the meeting pack and 6 to 9 of the table pack. So I want to welcome officials to the meeting. And we've got Richard Logan, who's the Finance Director, Andrea Quail, who's the Head of Financial Strategy, and Louise Blair, the Head of Financial Support. I want to thank you all for taking the time to join us today and welcome you to the meeting, and at this point invite you to make any opening statement that you wish to.
Thank you, Chair. Good afternoon, and thank you for the opportunity to update the Committee on finance-related matters for the Department. I'm joined today by Andrea Quail, Head of Financial Strategy, and Louise Blair, Head of Financial Support. We've already shared detailed written briefings with the Committee on the areas we'll cover today. I would therefore intend providing just a brief overview at this stage, with a particular focus on the December monitoring round outcome. The Department submitted its return to the Department of Finance on the 20th of November 2025, and that information was shared with the Committee on the same day, along with a detailed briefing outlining the main aspects of the Department's return. The Executive subsequently agreed the December monitoring position at its meeting on the 9th of December. The outcome for the Department of Justice included an additional £7 million of funding for PSNI workforce recovery costs and £4.6 million of funding for PSNI pay awards. The Department's available budget was also adjusted in December monitoring for technical transfers of £1.5 million. This included inward transfers for departmental solicitors' office costs and outward transfers for custody nurses, the Rowan Sexual Assault Referral Centre, funding for the domestic and sexual abuse programmes, and funding for the Northern Ireland Road Safety Partnership. In total, this brings the Department's non-ring-fenced resource style budget to £1.44 billion for 25-26. Business areas across the Department, including PSNI, identified a number of cost reductions and easements as part of the December monitoring process to help address the pressures across the DOJ budget. This was achieved by business areas taking proactive steps to manage their projected overcommitments and reduce expenditure where possible, mainly through vacancy management, but also by demand and costs being lower than original projections in some areas, including the prison service, compensation services and legal aid. However, it's important to note that these are not recurrent reductions and therefore will not assist in the management of future years' budgets. Together with the additional resource DEL allocation of £11.6 million from the Executive, the easements and cost reductions identified by DOJ business areas mean that the Department can meet in full its current stabilisation pressures of £17.9 million. These pressures include the costs of the PSNI Workforce Recovery Plan and Police Pay Award, which can now be demonstrated by PSNI to be affordable in 25-26. As you would expect when dealing with a budget of £1.44 billion for a complex department such as Justice, there remain uncertainties in terms of pressures and easements over the remaining months of the current financial year. The Department's budget will therefore still require continued careful management and stewardship. However, it is currently projected that the Department will be able to live within its resource budget for 25-26. In terms of the Department's capital DEL budget, this increased by £0.4 million in December monitoring to reflect technical transfers from the Department of Finance in relation to the Castle Buildings accommodation project. The Department's capital DEL budget is now £101.5 million. The Department did not need to submit any capital bids in December monitoring, but is continuing to manage pressures of £0.3 million. And historically, the Department normally has small underspends on its capital budget at year end, and this should allow this pressure to be managed internally by DOJ. In relation to ring-fence resource DEL for depreciation and impairments, the Department submitted a bid for £1 million relating to pressures in PSNI. However, the Executive was not able to meet any pressures for departments in this monitoring round. The Westminster supplementary estimates may result in additional ring-fence resource DEL becoming available, which will be allocated in due course on a pro-rata basis to departments based on the bids submitted. Finally, in relation to annually managed expenditure, or AMI, the Department's revised balance is £531 million for 2025-26. Treasury and in turn the Department of Finance do not set firm AMI budgets as they are volatile and demand-led in a way that departments cannot necessarily control. The main elements of the Department's AMI balance of £531 million includes £270 million for police pensions, which accounts for just over half the balance, £141 million for legal claims across a number of business areas, and £85 million for compensation services. The Committee will also be aware the Department faces significant exceptional pressures due to legal claims relating to the PSNI data breach, holiday pay and McLeod. The costs involved are best estimates at this stage, as there will be a range of potential outcomes depending on the eventual settlement of these legal claims. The timing of when payments will be made to settle the claims also remain uncertain. However, the current assessment is that these costs are more likely to be incurred in 2026-27 or later, rather than 25-26. Further engagement continues at both official and ministerial level between DOJ and DOF to secure the necessary future funding that will enable the claims to be settled. The necessary funding has not yet been secured for the data breach. However, the Department's understanding is that this issue will be considered as part of the upcoming discussions by the Executive around the multi-year budgets. The Department of Finance have confirmed they will commission a January technical exercise following the outcome of the December monitoring round. It has been noted that bids will not be accepted in the technical exercise and departments are not expected to submit reduced requirements at that stage. It will only be an exercise for necessary technical adjustments. The timescales for this exercise are not yet known. The Department will provide full details to the Committee of the Department's submission at the same time as information is provided to the Department of Finance. The Committee will already be aware the Department was successful in securing transformation funding of £22.6 million for 2 projects in the first tranche of bids for speeding up justice and also modernising electronic monitoring. The Department's budget for 25-26 includes funding of £5.1 million for the speeding up justice and electronic monitoring projects, and work is progressing on both. As part of December monitoring, the Department has actioned transfers for speeding up justice budget allocations to the Northern Ireland Courts and Tribunal Service, PSNI and Public Prosecution Service. In addition, there was a reduced requirement of £1.1 million for speeding up justice funding as a result of reprofiling budgets in order to maximise project outcomes in future years. The second tranche for transformation bids was launched on the 23rd of June this year, and the Department subsequently submitted 3 bids together with a further bid from the Cross-Executive Programme for a Trauma-Informed Approach Delivery Team within the NICS. We remain actively engaged with the Board and its Secretariat to assist in its considerations, and we await the final outcome of their decision making. We will, of course, as we did with Tranche 1, inform the Committee of the formal outcome when it is provided to the Department. Should the bids not be successful, separate funding will be required to ensure that the critical transformation work identified can still move forward. Just in terms of other matters, I'd like to bring to the Committee's attention a request from the Finance Committee in relation to the review of arm's length bodies and the ALB pay landscape review. By coincidence, the clerk for the Committee wrote to the Department yesterday on the same matter. The chairperson of the Finance Committee has written to the Justice Minister requesting an update with regards both reviews being progressed and that the broad review of ALBs will be completed by April 2026. I understand a similar request has been issued to all ministers and committees. The Department is currently preparing a response to the Finance Committee, which is due for return by 8th of January 2026, and our return will of course be shared with the Justice Committee. In closing, I trust that I have provided you with a helpful overview of where we are now in terms of our financial position. We continue to operate in an extremely uncertain financial environment, and the Department's position remains very challenging in terms of managing the budget in the current and future financial years. I'd like to thank you for the opportunity to provide the briefing today. We very much value the role and views of the Committee, and we're happy to take any questions. Thank you.
Thank you very much for that, and thanks for the paper that was provided. I suppose I just have one question, if you'll indulge me, and it's around the violence against women and girls. And I know obviously TEO are the lead on that particular strategy, and it's cross-departmental. But in terms of the bid, 24.6 million for resource and 4.6 million for capital, can I ask how that will be broken down? Like what is the objective for that money? What's the planned spend? And do we know when we have got a decision forthcoming on that bid?
In terms of decisions, it's still being considered. We don't know yet. My sense is probably the two that are most likely to still be in the running of the Ending Violence Against Women and Girls and the PSNI IT bids, but we haven't had final confirmation of anything, but I think that would be on my sort of informal view. In terms of the bids, we have shared previously with the Committee sort of details of the bids in full. Just bear with me. So in terms of the Ending Violence Against Women and Girls bid,
my apologies if that I'm new enough to the Committee, so
you're okay. I'm hoping that's part of it, or maybe isn't.
if you've already provided,
I've provided an update on certain things, but I can't remember.
you're 100%. If we've already received it as a Committee, I'll be able to get access to that. So apologies, that's my.
Even brief overview. So we know that within the Department, the Director of Victim Support has been working closely with PSNI, senior PSNI leaders and senior Department of Health officials, all of whom hold operational and policy responsibility for their relevant elements of the bid. Priorities were informed by alignment with the domestic and sexual abuse strategy. A scoring matrix was also used to consider each element of the bid against a range of relevant factors, including deliverability, evidence-based and interdependencies. Overall oversight and programme will be managed by the DSA Strategic Oversight Board, and if successful will apply the best practice and guidance within the teal book. So that's sort of the structure and everything, but look, we'll have, if you want more details, but there's full details, we'll share the full bids and everything, but can more than happy to reshare that.
You're 100%. My apologies.
No, sorry.
Thank you. I've got Connie next.
Yeah, thank you for coming in today. I just have one question as well, and really that's around what the department's projected capital needs during the spending review period are, and how much will be needed to meet those needs.
So as part of the future years exercise DOF commissioned earlier in the year and work we did on the departmental 5-year plan, our assessment based on returns from the areas is that on average over the next 4 years we will be looking at £270 million per annum. So at the moment our departmental budget is in the region of £100 million. That's a significant gap between what we currently have and what we need in an ideal world. But even if we were trying to meet just contractual commitments, the pressure in the budget is going to be very, very tight. We need those to develop and improve our facilities in the police college, their stations, the courts, RCJ, Bishop Street and Londonderry, forensic science facilities, all across the estate and prisons estates where we're trying to improve, make sure there are adequate facilities for anybody who uses the services within justice. And it's also important as well that with an ageing estate, and each year the maintenance costs are increasing and becoming increasingly expensive, so we need to modernise, get proper state-of-the-art facilities and reduce our resource spend in order to manage our resource budget as well. So it's critical that we get that expenditure and budget for that.
No, I agree there. I think we had a committee visit to the courts in Belfast, and a lot of us were quite concerned when we saw firsthand.
Whatever budget we get, we will have to prioritise, and certainly for 26-27, the prioritisation will be along the lines in the first instance of contractual commitments. So there's already projects that are underway. Commitments have been signed with suppliers, so we've got to honour those first, and then we need to see, depending on what budget we're allocated, what's left then to allocate for other priorities across the whole of the justice sector.
Thank you.
All right, Connie. Thank you. Patsy, Lanneray.
Thanks very much indeed. Two questions, please. The first one is, you've obviously noted that the reports into Operation Canova and Operation Denton came out through the course of the week. Can you advise me just what resources are provided and where they might be provided within budgets for any follow-up response that there could be at either DOJ or within the police, and any extra funding that may be required to see that through, please?
I think at this stage it would be too early to say. We haven't been given any costs. I think the Chief Constable would be best placed, certainly in the first instance, on the operational aspects of any costs.
Maybe, Chair, if we could at some stage, if that's okay with your forbearance, could we have the necessary officials and police in to discuss these matters, if that's okay?
You can put that on there. Look at that for the Forward Work Programme.
That's great. Thank you. Now, the second thing then is, in the middle of a maelstrom of different interpretations of the situation, what is the position as regards the police pay and also the compensation for the data breaches? Could you shed me just some light on that, please?
Certainly. So in terms of police pay, executive allocated 4.6 million to the department and police for police pay. So overall, there was the bids originally were 150 million between health, education, infrastructure and justice. There was £100 million available to the executive to allocate. Each department got a pro rata share of that. So our bid was 6.7 million, we got 4.6 million. Together with that money from the executive, police have had cost reductions as well, and the department, from the work that we have done to reduce pressures elsewhere in the department, we are able to fund fully police pressures. So that will enable police to deem that the pay is affordable this year. The budget allocation letter was issued to police just this morning, or just shortly after lunchtime today, confirming their allocation. Police will then review that against their budgets. The Minister will then invite PSNI to submit a pay remit and accept on the basis of the PRRB recommendations. Once police put that in, and we've already been working on getting preparatory work, so DOJ and PSNI officials, in anticipation of funding being available, we have been getting the planning and documentation reviewed and ready to go. there's still a bit of process in terms of governance to get things formally signed off by our Minister, Permanent Secretary and Minister, and then it goes to the Department of Finance for the Finance Minister to sign off. At that point then, that will go, police will have full approval to do it, and we're working, the aim is to progress that so it could be paid to police officers in January 2026.
I'm getting the process bit, Richard, but I'm trying to establish, if you can establish with clarity for me, A, will the police get their pay, and B, where is the compensation issue for the data breach?
So police, we're aiming, the aim is to progress the pay awards so it will be paid in January 2026 salaries.
2026.
For salary. In terms
the
of
other issue.
Yeah, so in terms of the data breach, Minister then, obviously the media coverage, Minister clarified the position on an interview this morning, and that's been followed up subsequently with a statement to a number of media outlets who had media inquiries about it. Minister's clarified that she incorrectly stated that the executive had agreed to fund the costs of the data breach compensation. The agreement was that DOF were going to submit a paper to the executive for consideration. So the Minister's explained the error to the Chief Constable and apologised to him. That apology extends to all the officers and staff who have been affected by the data breach, and the Minister will continue to work with executive colleagues to ensure this matter is resolved as quickly as possible. I suppose the key element of this is there's a legal obligation to pay this. We want to get the payments to the individual members of police officers and staff to get the amounts that they're entitled to, and we'll work with DOF as well as the Minister. We'll work with officials to endeavour to secure that funding for that. But it's a legal obligation that has to be paid.
Fulfilled. Just on that, and I know this, some of these factors are out with your control if it's going to other departments and that. But have you any indicative timing as to when that payment may be reconciled?
Yes, and it's subject to executive's approval of the funding. But if that was to be forthcoming, PSNI's assessment is that the payment would fall into the 26-27 financial year at the earliest. So it's not in the 25-26 financial year.
That's grand. Okay, thanks very much for that.
Thank you. Brian?
Okay, thank you, Chair. Thank you for your attendance at committee. I just want to ask, first of all, about the £7 million, which we were told was earmarked and has been provided for workforce recovery costs. What does that mean? Is that additional officers?
PSNI submitted a business case previously, and that was approved by Department of Justice and Department of Finance, and the caveat was it was subject to affordability. The premise of that business case was that at the baseline the police were working on was that they had 6,358 officers and 2,344 civilian staff. The business case intends to increase those numbers to 7,000 officers and 2,572 civilian staff. So that's an increase of 642 officers and 228 civilian staff. The intention is the profiling, and it was subject to timing for recruitment campaigns and the capacity within the college, but that it would built up over the 3 years, 25, 26, 27, and 27, 28. So it would take 3 years if everything went according to plan to get to those numbers. The reference has been about a 5-year plan. That's just really securing that it'll take time to get everybody in and then have 2 years at the end just to sort of stabilise things. So that's when it talks about a 5-year plan, it assumes though that the first 3 years are spent recruiting and maintaining officers.
Okay, so that will produce a new minimum level. Hopefully those officers will be sustained.
That's subject to additional funding being available. So the cost in the first year for the business case, it was £7 million, so that's been funded now. That then builds up 26 million in 26-27, rising to 48 million, then 60 million and 65. So the figures that's being quoted maybe in the media or elsewhere of 205, 206 million, that's a cumulative basis, and that's the difference between what it would cost to employ the current level, the baseline, and what it would cost, the increased cost of the additional officers and civilian staff. Okay,
that's good to hear. In terms of the transformation funding, 1.1 million of the Speeding Up Justice transformation funding was given up in this monitoring round. What in practical terms does that mean? And obviously I assume there'll be a desire that will be reallocated in a future year. What was that funding for, and why couldn't it be delivered this year?
It was just delays in terms of getting the whole project. So whenever the bids originally went in, which would have been sort of a year ago, there were assumptions made about how far they could progress in the first year, and there was a number of individual organisations working together to do that. So it's just been sort of delays. The profile hasn't matched exactly, or the actual spend hasn't matched what the profile was. But very much the point is it's been reprofiled to future years, that the money's not expected to be lost then to the department, that we'll be able to make better use of it in future years whenever further progress has been made.
And can you explain what specifically it was for, that 1.1 million? Or
I can't specifically, we can follow that up, but
Right.
it's probably a combination. There's a whole lot of different elements to the original bid, and there could have been slippage on one or more elements of that, but certainly we can follow that up.
Okay, and just finally, Chair, I mean, on the data breach compensation funding, certainly it is regrettable how this has ended up in the news, and I know that the Minister has apologised. Effectively, she got ahead of full executive decisions, and I think we're all mindful of the consequences for police officers, and the Police Federation Chairman did speak out on this. You know, this is affecting people's lives in a major way, and well, there are positive indications that this money will be found next year. Equally, I don't think the executive has given up the case to Treasury, and I think we would all agree this was an exceptional situation, and if Treasury can provide that funding, we should not give up on that avenue. But just as the Committee for Justice, I think we should write to the Minister or to the Department just seeking formal clarity, you know, on the situation of that funding. I know we will hear, hopefully in due course, but I think as the Committee we should be writing, just expressing concern on the impact of the uncertainty on police officers affected by the data breach, and just asking for clarity on the securing of that funding.
Thanks, Brian. Ciara?
A lot of my questions have been asked. I just want to follow up just on one, and then one or two others. Just in relation to the pay award, so it's 4.6, but you put in a request for 6.7, so there's 2.1 of a deficit, and you mentioned there has been some cost savings, etc. Yeah. Can you just clarify what is the final total, or do you know what the final total is within this financial year that's required?
The original 6.7 was a best estimate as well. Police themselves will need to work through the actual costs of what the pay award will be, because it depends what point on the pay scale people are, and just a whole lot of factors, but that will come through in due course from PSNI whenever they're working it through. And in terms of the shortfall as well, the department was able, I think it's a good example of when I came before on the previous reports where the police had pressures in around 21-22 million. I think it's been a really good example of collaborative work between the executive, PSNI and the department, that between those three groups we've been able to bridge the gap and secure this necessary funding to make that pay award affordable. So I think that's coming from the outset of the year. Minister's been very clear and department's been very clear that not to expect significant additional funding during the year. So we've had to put in place cost reductions and efficiencies from the outset, and the credit to the business areas, they have delivered on that.
That's where I was going to next, because obviously back in October you had advised an overcommitment of 32 million, so credit to yourselves, whereby you're basically saying you're now likely to maybe break even, so that's excellent as a department to be able to do that. So just generally, how were you able to do it? How were you able to account for that 32 in general? I don't, the detail, but it'd be interesting just to know, particularly then for other departments that are overspending.
So in June monitoring, we were reporting 32 million. Whenever I came up to the committee, the 11th of October monitoring hadn't been formally commissioned, and we were in the process of doing an internal exercise. So although it hadn't been formally commissioned, the department on its own then took the steps to do that. Our results from that had brought the pressures then down to about 22 million in October time, and there was a combination of reduced costs for well, the 32 million in June, the main elements of that were 22 million for police, 10 million legal aid and £1 million for prisons. We got down to 22 million in October by a reduction in legal aid costs. So that was, at the time, was based on sort of projections or assumptions at the time. That reduced to about 3 million at that point. Prisons and courts pressures reduced at that point as well. Now, we did get emerging pressures coming out for legal claims in other areas, but we'd got it to 22 million in October. And then the latest exercise, there were a number of easements. Police were able to identify some easements through as reduced utility costs, the counting treatment of how they were doing their leases, and profit on sale of the Desert Creek and Castledard properties. So they were able to generate some money. There were further reductions in the projected costs for legal aid, and nearly all other business areas managed their pressures out. So the point as well then is, it wasn't just police pressures that we ended up with. So the total pressures we were left with at the end of just December month, it was 17.9 million. 17.3 million of that was for police, but we also, the Minister was able to fund remaining pressures in the likes of Probation Board, Forensic Science, Policing Board, and Police Ombudsman rather than Policing Board, Police Ombudsman and Criminal Justice Inspection. So they'd managed down their pressures as much as they could, and the easements that across the Department identified, we were able to meet those in full.
Well, thank you.
So it's been a concerted effort across all areas rather than one single solution to anything. It's everybody doing what they can to live within their budget, and I think that's a theme that will have to continue going into future financial years as well.
Okay, thank you. Just one final one. It's just in relation to the quality screen, and the department noted that the budgetary pressures were having a significant impact on service delivery, obviously at the time in the Justice Committee overall. However, it assessed that there was no need for a quality impact assessment. How was that assessment made, and how can the department stand over this assessment, given that there's still going to be ongoing budgetary pressures and that will impact on services?
So I think that everybody was recognising there's significant financial pressures. The issues that were raised were deemed to be sort of relatively minor. They were raised but not significant. So overall, when we looked at the total 1.44 billion budget and the issues and the impacts, it was considered it wasn't a major impact overall. So that was the assessment. And I think a lot of what's happening in the department is we're not necessarily stopping one, two or individual services. It's stretching it. Now the result of that sometimes is things are slowing down and taking longer, but generally services are being maintained as far as possible from within the existing resources. So it's that sort of still the department still trying to do everything despite all the budgetary pressures.
And there's no, obviously, just one wee final one if I can, just in relation to obviously last year and the year before around legal aid, there's no slowing up of payments of legal aid.
No,
so we may have to wait months or move into the next financial year for payments. That's not happening this year.
No, so there's three main factors in terms of sort of managing the legal aid budget. One is the outcome of the judicial review, where there had to be appropriate timescales for payments, that the department couldn't manage its budgets through how it determined the timing. We also then have the volume and value of claims that at any stage we don't know. There are patterns and trends and we can model and everything, but we never know exactly in advance how much is coming in and how much it's going to cost. And the third element then were the potential, or at the outset of the year, were the increase in the level of fees, be it either in the general level legal aid and also the taxi master increase that came in June. Yeah. So at the moment, for the first 6 months of the year, criminal legal claims cases were being paid within 4 weeks, and civil claims were being paid within six weeks. And our value of unassessed bills was down. So that maybe comparable figures in the past, we can be setting up maybe 10 or 12 weeks. Mm-hmm. So that's the level we've been able to, and Paul Andrews' team have been very successful in terms of managing that. We still, and that's referred to in my opening remarks, of there are always uncertainties at this time of the year. At any time, legal aid remains in that category. Paul will never know if a high value claim or case comes in. However, at this stage, we believe that he can maintain his payment timings and live within the budget.
Very good. Well, thank you. Thank you.
All right, Ciara.
Yep.
Doug?
Thank you, Chair. Richard, thank you. Can I just ask you, just on the data breach, Richard, where does the figure 119 million come from? Because that seems to be the lower end of what we were talking about some while ago.
Yes, and I've prepared a business case and it's been approved by the department and DOF, and that includes a number of assumptions in terms of how much, what it's been grouped in. The claims have been grouped into certain categories of what we think the estimated cost to settle certain types of claims are. Straightforward claims, more complex claims, just different types. So there's a split of how the claims could be grouped, and also the potential value of settling those claims. Now those are our estimates based on, informed by discussions with legal counsel and everything like that, and police knowing what they know about the claims and the costs. It also takes into account estimated costs of legal fees and maybe court costs as well. So there's a whole lot of different factors. That's coming up with a range of potential costs. We won't know what the actual cost will be until funding is secured. Police can actually formally go into negotiation with the claimants to see what can be resolved. Our assumptions hopefully are accurate, but we will not know how accurate they are until those negotiations happen. The sooner we can enter into those negotiations, hopefully we can get the claims settled and minimise the cost of the public purse, because if they're not settled out of court, likelihood is that the costs, and that's what you referred to, other costs will increase if they're settled by the court or people don't accept the universal offer that's made to them. So we won't know until those negotiations happen. Legal teams consult with their claimants and we see what the outcome of how many percentage of people are prepared to accept the offer and settle out of court, or how many will want to go through the full court process for settling the claims.
Is there not 6 already going through the courts, Richard? And is it not a likelihood that the vast majority will wait to see the outcome of that before they then decide to settle? Because if you just imagine the Chief Constable gives an offer, but then the court case gives these people twice as much. Is that not a danger? And that's why I asked about how do we set 119. I mean, I don't know when those court cases are due to be heard, but have we got any idea? And secondly, have you got a ceiling? Have you got a ceiling where the executives say, yep, we're going to give you 119 million, but actually it's going to cost 220 million? And if you can't afford the access, you might not get the 119 million, if you understand what I mean. Do you have a ceiling?
So if I take the first element bit in terms of there is definitely a risk that people will hold off to wait the outcome of the court cases. I suppose it depends on, those court cases have specific circumstances, and it's whether or not every individual claimant would be in a similar position. So there are different levels and types of claims, like any sort of group litigation like this. There could be certain groups that get paid more, some people have a certain amount as well. So we don't know, but it's absolutely a risk that the longer it takes to try and make a formal offer and negotiate, it increases the potential risk of people holding off and waiting for a settlement. We just don't know what the outcome of that will be. In terms of a ceiling, what I would say is that the figures being quoted, 190 million, isn't a target that we're saying we want to work towards that. What we're saying is that's a best estimate based on numerous assumptions on claimants' costs, legal fees, court fees. It's not a target that we say we want to work to and spend that exactly. We want, in terms of responsibilities as public servants and public money, we want to minimise the costs, but at the same time balance that with a fair and reasonable settlement for the claimants. So it's not a target that we want to work towards. If it increases beyond that figure, then that's further discussions with the Department of Finance to see what we bridge if and how we could bridge any potential gap.
Yeah, and that's fair enough. I mean, there's a lot of unknowns in there. Yesterday's announcement by the Justice Minister that the money had been secured and been ring-fenced. I mean, you knew quite quickly that was not accurate. I'm right in saying that. How come you didn't put a statement out to state that was not accurate? Why did we leave it till this morning, even though the interviews were done yesterday?
Minister clarified this morning, so that was the timing that was in
No,
place.
she clarified yesterday. Her interview was yesterday, not this morning. So why did the department not put out something to ease everybody's jets, so we wouldn't have had this for all? What she did at the interview yesterday to say she'd misspoke. Fine, that's a mistake. Why did the department not put something out to say, look, it hasn't been secured, it hasn't been ring fenced, but we hope it will be in a week's time?
I think that was just a decision to let the interview. We knew the interview was going ahead today, and let it preceded that. So that was the position the department has taken, and the Knowledge Service has clarified that further.
And the department took that decision, did they?
Well,
So the department took the decision not to tell police officers?
No, in absolute conjunction with the Minister. So it wasn't a separate decision at all. It was fully in conjunction with the Minister. We've been engaged with the Minister on this.
So the Minister and the department took a decision not to tell the police family and their families that this was not accurate, is what we're saying.
It's probably not a question for you to answer. Doug, is there anything else you want to cover?
Yeah, just a very quick one. Sorry, I probably was probing a little bit, so apologies, Richard. Richard, the £7 million are really welcome for the workforce recovery for this financial year, although a little bit late. Can you just remind us what it's going to be for next year?
The cost in the business case was £26 million, and that would allow, in the business case, the figures for next year would be 256 officers and 77 civilian staff. Now, those are written at a point in time. They're leavers, joiners, and those figures will fluctuate. But that was the premise, and it's a similar figure. It's a similar figure in terms of numbers for the following year. But the cost will be £48 million because you've then already recruited 200 or 300 people by the time you get to that. So it's the cumulative effect each year that will be coming through.
So sorry, I pick up that. That's £48 million. Did you say that? That's what we're looking at, and I know the reasons why, but that's the figure we're talking about.
So over the next, if we include, 7 million was the first year. Year two was 26 million.
Right, got you.
Then 48 million, then 60 million, and then 65. So it's our levels of, by the time you get to year 4, assuming everybody's recruited, you're up to the levels of 7,000 officers and 2,572 civilian staff. And then those are just sort of mainstreamed in terms of those costs each year, and they'll increase by pay awards and other costs, and it'll always be joiners and leavers. But that's the profile that, whilst it's a 5-year business case, it's a 3-year profile of additional recruitment that's in the business case. And as I said earlier on, that's all subject to additional funding being made available. So those are the figures that were in the business case.
And I guess that's the important bit, that all has to be on additional funding coming in. That can't be from where you are now. That's additional funding, yes?
Exactly. And we've reported already to the committee, and we shared the 5-year plan in terms of the level of pressures going forward, and it'll be subject to what money is available. But even without the additional recruitment, all areas of the department are facing financial pressures going forward. I think I've maybe quoted this before, but next year, our pay bill across the department, all the organisations, will be in the region of £1 billion. So every 1% of a pay award is £10 million. So if there's a 3% or 4% pay award agreed, that's £30 to £40 million before we do anything extra. And you build in inflation, running at 3 or 4% as well in the remainder of our costs. That's essentially where our pressures are coming from. The main driver for the department's budgetary pressures, and it's similar across a lot of the public sector organisations as well, is pay. 70% of our costs are currently staffing costs. So that's their basic salary, employers' NIC, and we had the additional increase, the 1% increase this year for employers' contributions, and then pension contributions, and they range from 33% up to 46% contributions for police officers. So that's the range of additional costs that are coming through as pressures.
Brilliant. Richard, thank you very much indeed.
All right, Doug. Brilliant. Thank you very much, and thanks for taking the time to answer all our questions there. We'll let you go. We've got some...
Right, next meeting.
Yeah,
certainly.
is that
Thank
okay?
you, Chair. Thank you.
So with the committee's agreement, we'll maybe write to the department to ask for detail on the Violence Against Women transformation project and what exactly that will detail. Is everybody content enough with that?
Yeah.
And then we've got a request to write to the relevant Department of Justice officials and the PSNI around Patsy's request for Operation Canova and Operation Denton in due course. Is everybody content enough about that?
That's to get them to present at
On
some
that.
stage, Emma.
Yeah,
Aye, thank
so we
you.
have enough to action that. And then there was a request to write to the Minister for further clarity on the data breach issue, which is everyone content enough with
Can
that?
I just add a wee extra one, given that you're going to see clarity on the 24.6? Could we just kind of see clarity on the 1.2 of capital funding through the protocol funding back in June? Just to clarify what that funding is covering as well. It was 1.2 of capital.
Yeah, there's
Is
a
that
figure
okay?
4.6 for capital as well, which I think we've included in that, so we can.
Within the and violence against women.
Yeah.
Yeah.
Happy enough? Everyone content with that?
Yeah. Good. Thank you.
Okay, members, and we're only 6 minutes late, so we're doing well. We've got Department of Justice officials coming in now to talk about the remaining parts of the Justice Bill. So can I refer you all to pages 77 to 209 of the meeting pack? And members, you'll recall that last week we had sort of dealt with part 2 of the bill, so we've got the other parts to work through today. You might want to look at the raised paper on taxation reform, which begins at page 211 of your pack, and as well as that, in item 7 of your pack and your table of papers pack, we've got responses to queries that we had submitted for more detail at item 7.1, 7.2, 7.4 and item 7.5 and 7.6 in the table pack. Members might find those pieces of information useful. So I want to thank you all for your attendance today. We've got a bumper crew in from the department. I want to welcome Lisa Boal, Head of Policing Policy and Legislation Team, Brian Thomson, the Head of Access NI, Andrew Laverty, Justice Bill Manager, Lorraine Ferguson-Coote, the Head of Criminal Policy Unit, Máire Sheehan, the Senior Legal Advisor, Debbie Corry, Head of Organised Crime Branch, and Andrew Dawson, Director of Criminal Justice Policy and Legislation Division. So obviously, as I said, we dealt with part 2 last week. We're potentially going to go through this in parts again today, and I think in that line officials can come forward when the relevant area is being discussed. So if members are happy enough, we're going to begin with the biometrics section and the biometrics amendment. If you have any opening statements or comments that you want to bring.
This is our policy lead on biometrics, Chair, and happy for you just to start firing questions at us. I think we understood that we're discussing the aspects of the table of evidence where the committee's looking for outstanding comment or responses. Is that fair?
Yes.
Rather than a wholesale brief and Q&A on the full part of the bill. So
okay.
We're happy to be led by you.
Okay, so you don't have an opening statement as such?
Not as such.
So I suppose just the concerns in terms of the biometrics, and we covered this a bit the week before last or 2 weeks ago, around some of the concerns that have been raised around, I suppose, the change from the current practice and retention of data and what the definitions were going to be in terms of sort of exceptional circumstances or on what offences biometric data was going to be held as it currently is for longer than set out in the bill. If you would comment on that.
I'm not quite sure what you're.
The offences. I suppose there were concerns around offences other than extreme sexual violence offences and how that would be defined in terms of how the biometric data would be held.
So
like the qualifying offences section.
Qualifying offences. So whenever somebody's arrested for a recordable offence, their biometrics, their fingerprints and DNA would be taken. qualifying offences are the most serious offences, so they're the most serious. There's recordable offences in general, and then the qualifying offences are those most serious offences. So we had been doing some work to review the list of qualifying offences, and we had provided the committee with a report on the outcome of the consultation on that review.
Okay, and I think there were some concerns from the rights sector around children and how that was, in what circumstances children's biometric data was being retained and what they...
A child's biometric, if a child or young person is convicted and receives a disposal for an offence, and it's a recordable offence or a qualifying offence, their data would be retained, and the various retention periods are set out in the bill. So the retention periods for under 18s are generally shorter than those for adults, and there's a specific provision made in Article 63M for young people where it's their first offence.
Okay.
And then obviously we've set out the maximum retention periods in the bill, but there's also the provision then for the review mechanism, and the committee was also provided with the paper on how the review mechanism would work. So that would mean that although the material will be held for that maximum period, partway through that period, the need to continue to hold the material would be subject to a review by the PSNI.
Yeah, we had a conversation the last day around that and how that review would work, and I suppose there was a concern that that would still be under the direction of the Chief Constable, and that there's no truly independent reviewer. How is that going to work in practice in your...
Well, the way we envisage it working is something along the lines of the way that the current freedom of information arrangements would work. So whenever the material is due for review, the PSNI would carry out a review of the need to continue to hold that material, because the PSNI are the data controllers and the data owners. So they would carry out their review of whether they need to continue to hold that person's material based on risk, offending history, of a range of factors. So that's the statutory review process. If somebody writes in to request a review of their material, and the PSNI review it and they decide that they want to continue to hold it, and if the person's not satisfied with the outcome of that process, they can They can ask the PSNI to carry out an internal review. So that would be done by the PSNI, but it would be a separate person or team that would do it that way. So that would be the same way as the freedom of information complaints process would work. If the person's not happy with the outcome of the PSNI internal review, they would have the right to make a complaint to the Biometrics Commissioner.
Yes, so I think that's where we had thrashed this out a wee bit a few meetings ago. So the Biometrics Commissioner is still answerable to the Chief Constable?
No. The Biometrics Commissioner would be appointed by the Minister and would be an independent office holder, and they would have independent oversight of how the legislation around the fingerprints and DNA would work.
Okay. And so the point at which they would be sought is after 2 appeal processes, basically. So if somebody puts in an appeal, they're not happy, or puts in a request, they're not happy with the outcome, they appeal it again, and then on the 3rd time it would go to the Biometrics Commissioner. Okay. And that person is appointed by the Minister and is completely independent of the PSNI?
Yes.
Okay. Thank you. Who have I got? Ciara?
Thank you. I've just a couple of questions. First one would be, look, obviously I recognise the information you provided through regarding the applicable court's privacy notice and the information that would be entailed within that, which are going to be externally published and available to anyone attending remote hearings. And equally, obviously, it would be illegal to record. However, I would also be interested to know how the department will satisfy itself regarding that children and other vulnerable groups can adequately understand proceedings, can fully understand what they're consenting to, know prior to proceedings how they can participate effectively, and have been adequately informed of their rights.
I think that's relating to the use of live links for courts and tribunals. Are you?
Yeah.
Is that?
Yes.
Yes. So, sorry, that's a different section of the bill.
Sorry, that would be mine. So,
Sorry, we've jumped ahead. Are
we're going to...
are we moving off
leaving
biometrics, or are you...
We're going to do it section by section.
Right.
Or have we got any other questions on biometrics?
Right.
Brian, go ahead.
Thank you for your attendance. I always feel duty bound to question the need to create another Commissioner's office. So what happens in other jurisdictions in the UK and Ireland? Do they have standalone biometric commissioners, or in any of those jurisdictions are they tied in with other existing posts? where an existing post holder can carry out that function?
In Scotland, they have their own biometrics commissioner, and he previously gave evidence to this committee, as I understand it.
Quite recently joined, yeah. Go on.
So there's a Scottish biometrics commissioner, and I know that his advisory group, and I think he works quite closely with other relevant bodies in Scotland. The England and Wales position is under review at the moment. There is a UK biometrics and surveillance camera commissioner, but a Home Office launched a consultation last week, and they're looking at reforming. They're looking at reviewing their oversight arrangements. So I think they're taking views on what a future commissioner's role might look like and how it would link in with other bodies such as the Information Commissioner and the Investigatory Powers Commissioner. So I'm not quite sure where that's going to go in future.
Okay.
But we're proposing setting up a biometrics commissioner here for Northern Ireland to provide that independent oversight of how the legislation would work in practice, because we thought that because our legislation is slightly different to England and Scotland, that it would be useful to have a local commissioner with local knowledge and able to work more closely with local bodies and local stakeholders. But we anticipate that they would work quite closely. I don't know whether it would be memorandums of understanding or other sorts of arrangements to work closely with the Information Commissioner's Office here and other sort of relevant oversight bodies, but we felt that there was a need because of the sensitivity around all of this and taking account of the European Court judgment in the Cochrane case, that it would be appropriate and an important measure of ensuring public confidence to have that independent oversight there and that sort of that specialist function, to look particularly at the issue of retention of fingerprints and DNA.
Okay. And in clause 63Y of the bill, just I think I asked this before, but in terms of exclusion, of certain types of offences or coming under Terrorism Act, the International Criminal Court Act, Terrorism Prevention and Investigation Measures, Counter-Terrorism, Border Security, National Security Act, there will be exemptions. Will there certain biometric data will not be deleted for lifetime for certain serious offences, or what will the limits be?
It will depend on the legislation, and that's because those are exclusion because they're reserved and accepted matters. So, for example, under the counter-terror legislation, if someone's convicted of a terrorist offence, their material can be held indefinitely, but that's all legislation and retention periods set by Home Office. It's not within our scope to legislate on that.
Right, so, yes, so all of those ones are set by Home Office because of the seriousness of the offence?
Yeah, because they're reserved and accepted matters.
Right, and that applies obviously for offences within Northern Ireland then, even if they're being investigated by the local police?
Yeah, even if they're being investigated under counter-terror legislation by the PSNI, the counter-terror legislation is still a reserved or accepted matter.
Okay, thank you.
Thanks, Brian. I don't think anyone else has indicated. Speak now or forever hold your peace. We had a conversation the last day too around whether or not photographs were considered biometric data, and I suppose there's been again concerns or worries flagged by Nikki and other individuals around the fact that I suppose we're moving at fast pace here, and all of this I suppose needs to be future proofed. It's not considered in the bill. It's not included. What's the rationale for that, or where are you at in that?
The measures that were taken in this bill were specifically to address the issues around fingerprints and DNA. That's been the position because that's what's covered in the existing PACE legislation, and that was the initial issues coming out of the European Court judgments that we've had to address. Images has been an evolving thing in recent years because obviously we've tried to do the fingerprints and DNA amendments on a couple of occasions, and it just hasn't worked out like that. And time has progressed, and the developments around the use of images and technology has progressed. But there is a difference between a photograph as an image and a photograph at the point when it becomes a biometric, as you know, and that's considered when it's sort of templated for formatting and that. So that's been a recent development. But we want to get the solution around fingerprints and DNA in place first, but we want to look at images in more depth to look at the need for policy and legislation around images. At the minute, PSNI have said that their policy position will be to apply the same retention to custody images as they do to fingerprints and DNA, so that will achieve the same effect in purpose in in the meantime. But we do want to look at the policy and legislation around images, because you'll be aware that Home Office launched a consultation last week around images, facial recognition, the use of technology and stuff. So we want to see what the reaction is to that and where all that goes to. I know Scotland is also considering this, so we want to take account of developments in England, Wales and in Scotland, and to start to think separately about images, because it's not just the use of images, but it's the definition, it's the use, it's how they're shared, it's how they're retained. There's a range of issues that we want to look at there, so we want to do that, come on and do that as a separate piece of work.
So would you propose that once the British Home Office finish their consultation, and depending on what way they act, that this would potentially come under secondary legislation, or it's just...
It would be, if we were to do legislation, it would be primary legislation here.
But at some point in the future?
Yes.
Yeah, it wouldn't be a part of this bill.
Yeah.
There's just too many issues to work through whenever you start to think about definitions, and it's not just retention. We want to look at use and sharing and processing of images, because there's, when you start to think about future proofing, there's also the development of technology around facial recognition, and we'll want to make sure that we think about the issues there in terms of rights and privacy and safeguards and all those sorts of things. And we want to take the time to do that, because that will take a lot of consultation, particularly with human rights organisations, because we know that already we've seen some of the concerns already expressed around facial recognition, and we want to make sure that any policy or legislation that we bring forward in that space has all the proper safeguards and has the proper consultation given to it. We want to take the time to do that properly. We don't want to rush anything.
This is probably more of an operational question. So are those photographs, are they currently retained as per biometric data, as per PACE? So they are
currently retained by the PSNI, so they'll apply the same retention periods to them as they will to fingerprints and DNA.
Okay, but it's not set out in legislation.
Not in legislation, no.
Ciara, do you want
just to follow up on that? Obviously, you have heard it's been a concerted concern with most of those that have come to the table. It's a missed opportunity. I don't think we should be waiting around for other jurisdictions and other legislation, particularly around photographs. We haven't future-proofed this. I do get your understanding about facial recognition, etc., but from a human rights perspective, these photographs are being taken, they are being used, and although you have said the police will continue to use them like they do fingerprints, there's no statutory duty for them to do it. So it's not a healthy position to be in, to be honest. Is there any possibilities at all that photographs could be recognised as biometric data within this bill at this moment in time?
I just don't think it would be possible to do. We wouldn't have time to do the proper process of consultation and policy development. It just wouldn't be possible.
It's likely that would require significant drafting resources from the Office of Legislative Counsel as well. It's not something that could be developed at pace because of the human rights concern. There's obviously a lot of interconnected legislation that you would want to make sure there's no unintended consequences by bringing something in on top of what's already a set of provisions in the bill, which are already subject to another set of further amendments. So it's
all of that notwithstanding, though, it's probably the human rights concerns relating to it are already very much there if that data is already being held by PSNI on a sort of ad hoc or informal basis. So I suppose but are you content enough?
No, that's fine. No, thank you.
Can we move on then to the next section, to the live links? And I don't know if you require a shift at your top table.
Well, there's two sections to the live links arrangements, Chair. We've got Lisa, who's responsible for the police live link provisions, which are clauses 20 and 21 of the bill, and then we have Máire, who's policy lead, senior legal advisor on the live link amendments, which are the wider use of live links in courts and tribunals.
Okay, so I've got Ciara, and if anyone else wants to indicate, wheel away.
Apologise for moving swiftly on. So just back to my first question, obviously in relation to the privacy notices that you have noted and the role that they will play in relation to attending remote hearings. Just interested to know just how the department satisfies itself, and obviously I've raised this on numerous occasions about children and vulnerable groups and how they can adequately understand the proceedings. They can fully understand that they're actually what they are consenting to, and they know priority proceedings, how they can participate effectively and are adequately informed of their rights. So it's just around that area to ensure, and I know live links, obviously it's happening already, but I have raised concerns regarding particularly those vulnerable young people, those that maybe do not speak English as their first language. How are they fully engaged and informed and know exactly what's happening?
Well, there's a number of things that you're raising there, in which there's a number of different measures that are in place, if I put it that way. First of all, English not being the first language isn't a new thing in the courts and tribunals. So there is already well-established procedures for the provision of interpretation in relation to it. There's practice protocols in relation to it between PSNI and the court service, and that's in the criminal sector, in the tribunals as well. There will be the same facilities of obtaining interpreters. So that, I suppose, is the first thing about it. The other matters that you say about vulnerability, well, clearly there's the registered intermediaries that have come into place for a child who's having difficulty, or for any person who's having difficulty in their communication in relation to whether it's because of neurodiversity or whether it's because of some other vulnerability. None of those are new to the justice system. So in terms of children within, say, contact with the courts, if that, it's quite limited in terms of both the criminal and even in the civil. You'll very rarely see children being given evidence in civil where there's, shall we say, an adult who is also involved in the civil matter in relation to it, or in the family court, unless they're a certain age. But the feedback that we have got from those who also, shall we say, are dealing with the children, like the guardian ad litem, or the Young Witness, Victim Support Young Witness programme, they would actually have accessible document for children that are preparing to come to the remote evidence centre. And that, I'm sure you've heard on other occasions about the positive feedback we're getting from the fact that the remote evidence centres have also allowed where parents are accompanying a child or are also a witness in the same case as a child victim of a crime, that they're also able to avail and be in the remote evidence centre and give their evidence remotely. The other thing I would say is, first of all, the remote evidence, it's only a permissive provision. It's not a requirement. It's not changing the whole system of the courts, and in particular for the things that you would consider the most essential, that people know what's happening and where they're around the days of what you might call the contested hearing or the day of trial, whether it's civil, criminal, or whatever. Those are more often in person, unless it's a child or a witness, a vulnerable who's entitled to special measures, and that sits totally separate to the proposals and the amendments that we want to introduce. They're absolutely separate to that. They're like at the top tier. And then maybe somebody who wasn't eligible for special measures but has some concerns. The clauses have been drafted so that it's not just the parties whose views are taken, but the witness, the person involved, who might want to then say, well, can I attend remotely under the interest of justice test because I've got maybe caring responsibilities, or I've got a difficulty, and their evidence will then be assessed and their reasons for it against the Lady Chief Justice guidance. And you will see that in that there's new guidance just issued there in October 25, and with that the form that's attached to that, as well as the information that's given to anybody applying online, for it, will tell them to make their application with reference to the Lady Chief Justice guidance as to why they think it's in the interest of justice. Now, quite often, it's more often the professional representatives, if they have that will put in that application for them. Criminal matter, if they were witnesses, it will be the Victim Support Unit there in the PPS that will obviously get the information from PSNI. So there's, as I say, there's lots of different avenues that, shall we say, that people will get the information for it, and then the assessment. And in the end, it's still going to be a decision by a judge. as to whether or not, for this witness and this case, in all the circumstances, is it in the interest of justice for them to give their evidence in person or remotely?
Does it currently be monitored?
When you say monitored, I'm wondering what the
sense of, well,
parameters.
feedback.
I'm wondering what the
You
parameters
currently
are.
get feedback on how they've been able to experience
Well, yeah, I mean,
the live links.
from a number of the
engagements.
engagements,
I have visited the remote centres.
Well, we've got
and
the-
I can see how effective it
The
can be.
Victims
but
Commissioner has given positive feedback in relation to the use of the virtual remote attendance, and in particular is very keen to see more being able to, for those victims who don't meet the special measures test, but being victims of crime. Children caught up in a case we've had positive feedback from parents accompanying their children for that experience. Woodlands Juvenile Justice Centre has advised us that they feel the hybrid kind of court hearings, particularly for, not for, shall we say, for sentencing maybe, that can happen. They say it means that they have the young person in their care has somebody that they're familiar with nearby, so that they can communicate, understand what exactly the sentence is, or maybe if it's been that's been imposed, which should it be on a plea, but equally when it's for a remand, that again support them for in case they're disappointed, maybe that was an application for maybe them to be released from custody or that, and maybe it hasn't happened. And they have the support of those that they're familiar with. The Guardian ad litem has advised us that they see a number of benefits, and that families and young people have commented to them on the benefits of being able to join at an agreed time, reducing their anxiety and waiting time in the court. They're all specific real-life examples being given of those in different areas of the courts, where we're being advised that for those who want to use it and who are allowed then to use it, that they find that a positive experience, but not everybody wants to attend remotely. At times we've had feedback from victims that they're individuals. They have different choices. Some people want to be present in the court, and I'm not talking about the special measures, because generally everybody will apply for those if they're eligible for them. But I think it's, as I say, it's because it's a permissive tool, it's not a requirement. Nobody's going to be compelled to attend remotely in the absence of something like the pandemic, where then exactly. In the absence of that.
It's just for clarity, and I obviously welcome all the positive response, and I have visited the remote centre and I can see the range of tools, but there's no systematic monitoring and there's no plans to systematically monitor users at all levels, whether it's in a custody suite, whether it's in a court.
Well, the custody suite, I'm not.
No, you're not, but even within the court
that.
suite, there's no systematic, the department has no plans to do a systematic annual review or biannual review of court users, for instance, that have used video links or anything like that, is there? Because I do think, and obviously it may be well, but things evolve and change, and I think it's pertinent obviously to constantly monitor and evaluate the service as things evolve. As we've spoken earlier, things can evolve quite quickly.
Well, generally it's responsive.
Sorry, I was going to say, I don't have it here, but we've been compiling material to fill in the blanks in the table of evidence to return to you all, and as part of that we've got input from colleagues in courts which specifically addresses the monitoring and the use and the recording of use of live links by Themis. And so there is input. I won't embarrass myself by trying to repeat it with this brain cell that I have occupying the space at the moment. But there will be material in the table of evidence that will return to you specifically around that point.
No, that's fine. No, that's grand. And just one other one, just the Justice Video Platform training. Is this the only training covering the updated service provision, or does this include training on circumstances in which live links can be used And also does the training outline to staff the safeguards that should be in place to ensure such technology is accessible and used appropriately. So it's just around the actual training that's currently available, not just the video platform training.
Or the up?
Sorry, to whom? I'm just wondering, because clearly there's the Justice video programme there, and I mean, there's an 8-page document that's available when people are being invited to access, because it's already being rolled out through different courtrooms. But there's separate training that has been done for the judiciary, as I understand it. Okay, in terms of the instructions, this is like a different form of WebEx, so it's a scaled up version of WebEx that's been thing, and WebEx is something that already was one of the tools available for audio and video links. As I understand it on the operational side, and it is very much the operational side, there is a kind of instruction sheet that, shall we say, clerks maybe coming into a court would then be checking that it's operating as it's supposed to do so. And I say this from an experience in part of my engagement in the policy thing. I attended both in person and with remote hearings happening, but also attended remotely to see what was happening, and was able to bring to the court's attention that perhaps the clerk that day had not been checked the cameras, because there was there's a requirement even under the coronavirus provisions that the person attending remotely can see and hear the relevant players in the courtroom. And the angle had gone off, so there was a reminder then put around. So look, human error can happen in relation to it, but as long they all are aware of it's necessary for the witness attending remotely to be seen and heard by those who are also attending or are the active players in the court system, so that's the judge, the lawyers, and that it is not so essential that the public can be seen and heard. They can see, but not necessarily have to be seen by the witness attending remotely. That's the difference that we're introducing in the amendment clauses, because that's just one difficulty that the technology may not always be able to meet. And in particular, there's an express reservation for some of the measures that can be put in place, again, where somebody is entitled to be screened by the order of the court because of some reason from somebody present in the court.
Okay, Ciara. Anyone else got any questions on live links? No? So we can move.
Chair, with your permission then, can we excuse Lisa and Máire if that's their business
concluded?
Of course,
yeah. Williams away.
We're going to bring Brian forward, who is going to speak to the Access NI provisions, both in the bill and the amendment.
Thank you very much. Do you have any opening comments that you want to? I know part of this is a planned amendment, so I suppose, and members will probably have realised that the raise paper that we have on the taxing master relates, I think, a wee bit to how this is going to work in practice and the decision.
Chair, we don't actually have anybody here to speak to the taxing master legal aid clauses, because we didn't think that there were any outstanding issues in the table that meant that they should be here.
Well, that's okay. As I understand it, the change to how those fees is going to be worked out is kind of taking a wee bit of the power away from the taxing master and how that currently works.
Wouldn't presume to know the answer to any question around the legal aid provisions. That's an error on our part, Chair. I made the call on who was to attend.
No, you're fine. You're fine.
But certainly we can follow up on any issues that we're not able to address in person here today. But certainly we didn't see anything like that in the table of evidence that required some further comment or response from the department on the taxation stuff, other than is this a new research paper that has only just been compiled?
In terms of,
or-
it's a paper that we've been presented for this week, and
Right, so presumably that will be issued to the department, and the department will be providing a response to that then in writing?
well,
Yeah.
aye. Have I misunderstood now who that's?
No, you haven't. That's what. That's what we asked for there.
Yeah. Okay. Okay. So I suppose then, because there's a planned Access NI amendment. Are we?
Which Brian is here to speak to.
Okay. Are we getting sight of that then?
You've already got.
Sorry. In terms of the amendment that's planned before consideration stage, like
Which
it's
received and has been published as part of the call for evidence.
yeah, it's
There's two Access NI provisions. There's the provisions which are in the face of the bill, which are about automatic.
Yeah, so there's clause 29 about the role of the independent reviewer and the treatment of youth non-court disposals in the disclosure process, and then there's clause 29A, which is the amendment, the list of specified offences and how we're going to re-present that in the Police Act in a new schedule, and some other associated clauses around that.
That's commonly referred to as the filtering scheme.
Yeah.
Which is where old and minor convictions are removed from criminal records.
so that's been brought. That's already came to the committee.
It's come to the committee, and the committee feedback from the committee was we wanted to do it by negative resolution to speed up the process, and the committee wanted it to remain as an affirmative draft resolution. So that has been agreed, and that's been fed back to the committee.
Okay.
Yes, and we haven't shared it with you yet because it's such a small change, but we have an amended provision with the change from negative to affirmative resolution instrument built into it. So that has been actioned. There's no further requirement, as we understand it, in terms of what the committee would like to see in respect of those
Okay,
provisions.
and that's going to come to the
We
committee
can share that with you at any stage.
before March. Okay. Does anyone else have any other questions on this section? No, I think everyone's happy enough.
Well, then,
That was a
again,
short
with-
set.
with your permission, Chair, we'll excuse Brian and we'll bring forward Lorraine and Debbie. And then this is the repeal of the Vagrancy.
vagrancy. Yeah.
Yes, Lorraine can speak to that policy
Lorraine.
area.
Okay. And I suppose, do any other members have comments here? I know there were concerns around, and the department had given a view in terms of the Professor Brown proposal, that the department are not minded to implement what is there. But maybe is there a bit of vagueness around what the exact replacement for the current?
I can talk to the Kevin Brown proposal if you would like me to proceed with that. So,
Well, to be honest with you, I'm content enough because I had a similar view myself. So, unless other,
if you want to sort of
maybe Brian's indicated, is there something you want to touch on, Brian?
Yeah. Well, in terms of the wording in the bill, I mean, I am concerned, our party concerned about whether it will give the police sufficient tools, just to repeal the Vagrancy Act and the message that will send out. So we are disappointed by the response from the department, on Professor Brown's paper. We think there is merit in it, so it's something we may well bring forward and look at in more detail. Just because of we understand that the Vagrancy Act, the actual wording of it, is out of date, and it's not enforced, so in terms of someone either sleeping rough or people begging are not just automatically arrested, that's not seen to be the solution. But countering that is, if the public messaging is that sleeping rough and begging in the streets is no longer that there's no longer legal issues with that, that it's acceptable, and that the police can't take action. We're concerned that that could be the perception, and we recognise that there are issues relating to harassment, and I hear that from members of the public, particularly going through the city centre, and we've heard from businesses, on the real life consequences from them if they're having to clear up what is left behind by people sleeping rough or asking people to move on. We don't want to get to a situation where people are refusing to move on, where they're causing nuisance and harassment, and to do all that in a way which understands vulnerable people, but all members of the public can be vulnerable if they're feeling harassed or intimidated. So we feel there is the need to ensure that the police have all the necessary legislation, that they don't have to wait until an offence, a more definable defence, is committed before they can act or can encourage and persuade someone to either move or to change their behaviour. So that's what we feel, just in terms of particularly public spaces, city centres, town centres, main shopping areas are key locations, and that they need to be protected in terms of the public square.
Okay. Well, thanks for your question, and maybe I could sort of cover off the Kevin Brown amendment and expand upon our response given to the committee on that. So, of course, we are grateful to Professor Brown for his consideration given to this area. Professor Brown, as the committee knows, responded to our consultation. The department's review, we carried out the review of Section 3 of the Vacancy Ireland Act 1847 in relation to begging, that criminalised begging currently. And this, centring on begging because this is the focus of Professor Brown's amendment. And we carried out the public consultation, obviously, on that, which sought views on the repeal and whether or not there are any gaps that would emerge as a consequence of repealing Section 3 in its entirety. And the department is of the view, continued review, that no replacement legislation is required, that there's sufficient offences available in the modern legislative framework which would allow the police to deal with anyone who crosses the criminal threshold. We don't support Professor Brown's proposals because we think it would continue to criminalise and marginalise simple begging and some of the most vulnerable persons in our society, as you point out. It doesn't revolve around the complexities of the issue of the people that this involves, and we would say that it requires a multi-agency response beyond justice. Criminalisation adds to an already downward spiral, and that's something that came out very much in our consultation responses. People who are simply begging should not be treated differently from others within society who cross the criminal threshold, and they shouldn't be marginalised. So they should be treated in the same way as anybody else who crosses that. Just because they're begging is not justification for someone to be criminalised. And why should they be treated any different than someone who crosses the criminal threshold? The proposed decriminalisation of begging requires a different approach, a different mindset. We have to turn our mind to taking begging out of the equation when it comes to criminalisation. So there are sanctions against a person who assaults someone should be pursued solely on the basis of the offence of that assault, not because the person's begging. The measures proposed in Professor Brown's amendment also raised some concerns around Article 8 ECHR, and I'll be specific about that. Aside from Clause 1, which is the clause around the aggressive obstruction, etc., then he goes on to talk about the moving and persons on, and if they don't move on, they're criminalised, and they would be given up to a £500 fine. And these centre on simple begging. So we've relied on a particular judgment of Lakatos versus Switzerland. It was the European Court of Human Rights judgment of 2021, and it concerned a young woman who'd been fined for begging and been in a blanket ban of begging a particular jurisdiction, and being unable to pay the fine. She was in prison for 5 days. The woman had no other means of support. She was unemployed and she wasn't in receipt of social benefits. The court stated that the interference with the applicant's rights was not necessary in a democratic society, and that the right to call on others for assistance went to the very essence of the rights protected by Article 8 of the Convention. Any restriction on begging needs to have a legal basis, that's legality, and aim at a legitimate purpose, that's legitimacy, and must be necessary in a democratic society, which is the proportionality element. We're concerned that in some ways this will be a backward step if this proposal was brought forward upon repeal, and in a sense it's reinstating the former, the current law that we have, Section 3, but when it's repealed. The PSNI, they currently engage in engage and explain approach, where they assess the situation of someone that's begging. They establish the circumstances, they direct them on to appropriate agencies for support, and arrest is a last option. So their application of the legislation of Section 3 at the moment is proportionate in our view. But if this legislation was introduced, as with all new legislation, there would be an expectation that the police would have to actively apply it, and that is right. If you make a law, it should be applied. So we would be going back on ourselves. We consider this result in the most vulnerable in our society being further marginalised and stigmatised. And there's also risk with the implementation of a challenge of ECHR, Article 8. And we're concerned too, the penalty is £500, and this is a sanction for someone who's begging. So that's, and the reality is, if they don't pay that, then that runs into an even more serious sanction. So that's our views on the overall. We would apply caution to the particular proposal. We do think we'll be going backwards. It would be in line. It would be out of kilter, I should say, with the rest of the UK, because Scotland at the moment, they don't criminalise begging. They use current powers to deal with the behaviour, and this is the important bit. It is the behaviour. And if Clause 1, for example, if we go to the actual clauses, Clause 1, whilst that wouldn't necessarily, it would be in the margins of appreciation of that JR, its application wouldn't necessarily, there's always that potential for it to go wrong and infringe that, because we have to take the begging out of it, and we have to treat someone who crosses the criminal threshold the same as a member of the public. If that isn't, and we don't have a different mindset to people begging, then if this amendment did go through, then Clause 1 essentially on its application could be confused, and it could breach the Article 8 ECHR, because the application, unless the behaviour of aggression, or in this case harasses, intimidates or assault, unless that's the bit of this that's actually dealt with in this offence, then you would run contrary to the Lakatos judgment, and that's a really important point to make. We do feel it would be a step back. I mean, I'm happy to go through the elements of, all of the elements of Professor Brown's provisions, but there are particularly, beyond Clause 1, which we think does sort of work within the margins mostly of appreciation of the JR. There are difficulties there if it's not applied properly, if it's not implemented properly, but the rest of the provisions around moving people on, people are being marginalised. You're moving them on, what for? You're moving them on for simply begging, and that's the reality of this, whether they're outside premises, business premises, where they're at an ATM or whatever. There are issues around, we talk about how people feel safe and intimidated, and our consultation was well supported on repeal. We had 11 responses, 9 of which supported repeal. The two business areas that the bids in Belfast didn't, because they felt that that replacement legislation was needed, that we needed a power to move people on. But the reality is, what are you moving that person on for? And I know the police share that view when they give evidence to the committee. You're moving them on for simply begging, and you are marginalising those people. So that's the issue we have primarily around that. And the bids are also there to ensure that there are safe spaces in the city centre, that they're attractive to customers and businesses. Just because someone is begging isn't a reason, to criminalise. And if I can just find, there was an important part. The judgment actually did touch on this, and it said, an attempt to reduce the visibility of poverty in a city and to attract investments are also no legitimate aim to restrict the right to beg. And I think that's a very important point to make. I think we all need to turn our attention, police, public and businesses, to the fact that, people may feel uncomfortable with people begging. It's not a new type of behaviour. It involves very complex issues for the people involved. And as we heard, this morning there in the news, that 58 homeless people, and I know we're talking about begging, but quite often they're tied up with rough sleeping as well. People who are rough sleeping or begging. But there were an estimated 58 homeless people died in Northern Ireland last year. The highest number of estimated deaths in one place was 20, and these occurred in Belfast. They were mostly drug-related cases, and I think that's an important point to make as well, that these are and they deserve not an approach to criminalise, but to nurture and understand and support. I mean, we've talked about this before in our last session, so I'll not labour that, but I think they're the important points to make in terms of the proposal.
Yeah, we had, thanks Patsy. No, we had a conversation, I think, the last day around the need for compassion as a priority. Did you want back in, Brian?
Can I just come back in? Look, yes. And I understand what you're saying. And over the years, I've engaged, with homeless charities extensively. And when I find people begging, I've often given them something. I don't give them money. I would give them food or a drink if I can. As a policy, I would not give money, because I think that quite often is used for addiction, as yes. You've spoken about. And I would always encourage people not to give money to people who are begging, because quite often that is to feed an addiction, which is not in their interest. But I recognise a lot of good work helping people who are in that scenario of particularly people sleeping rough. But I still, it is a matter we will be looking at as further amendments. My notes from previous meetings are that the police felt that they could not deal with begging when it goes beyond an acceptable level, just with the simple repeal of this. In Republic of Ireland, they have a power to move on, for example, if begging beside an ATM machine. And I think there is the need for police powers where there is begging causing harassment, obstruction or impeding the public. And if you were the person running a shop and someone was every day taking a position, begging outside, you might have a view on the power to move on, that you can tolerate something for a while. But there's no point in us getting into a whole debate about it all. I do feel there is the need, because I think begging is an activity. It's not a passive activity. It is something which impacts on people, and I do think there has to be limits where the police can act when it is causing that level of nuisance or harassment. So it's something we will continue to look for.
Sorry, yes, I could just come back and respond to a couple of your points there. An important point to make is that in treating begging a different way to any other element, I mean, there is some concern around someone feeling safe or feeling, you know, they're not intimidated or harassed, but everybody's perception and how they feel uncomfortable is different. And there are no current powers to move on. For example, if you had a group of youths in hoodies standing beside an ATM, some people might find that intimidating or feel really uncomfortable. Or a group of men, if you're a woman standing at the corner of at a pub or outside a street in the city centre. And there are no current powers to ask those people to move on. You know, you're simply asking them, and we have to put our trust in place on the ground that, you know, resolution before people, like, I suppose, use of force or you have, you know, conflict resolution is what we're talking about here. The first method that the police will use when they respond is to talk to that person and talk them down, talk them around. And with youths causing annoyance, and I'm sure they far outweigh someone begging, because that very much is neighbourhood's bread and butter. But, you know, you move those young people along. But where do they go? They go to somewhere else, etc. But you don't have any criminal power. You don't have any power to move that person or to arrest them, as Professor Brown is making. Now, so that's the first point to make. The second is that the Lakatos judgment comes after the 2011 legislation that was brought in the Republic of Ireland. In England and Wales, there was an attempt by the previous government to bring in this type of thing, the nuisance begging, and that was strongly resisted, even by some Conservatives. And there was in the Crime and Policing Bill, which I know has the two measures of the facilitating someone to beg and also the trespass element. They tried to bring in something from the previous Criminal Justice Bill back into the Crime and Policing Bill, and that didn't hold any ground at all and was withdrawn. In terms of the Dublin experience, there was a survey carried out in the south of Ireland. I'm just going to try and find it here. First of all, if I sort of point to the Garda and the Dublin City Council, and they announced a new strategy to take Dublin's 50 most persistent beggars off the street. And the Assistant Garda Commissioner, who has this power, obviously, around ATMs, etc., to move on, stated that the activities of the group, who were almost exclusively homeless, were being dealt with as a criminal justice issue when in reality their begging was a result of a number of problems, including addiction, and required a multidisciplinary approach. So the Guards, even with that piece of legislation, you know, they feel that's different as well. And there was a survey done by the Dublin City Council, and there were mixed views on the legislation that was brought in. Some were saying that the begging had increased in Dublin city centre, and that regardless, begging was reviewed as a social issue and not a criminal matter and should be addressed that way. So there were a number of things that point to the fact we shouldn't criminalise people even with this legislation in. Scotland don't have it. England, Wales are not going to move that way either. The Labour government is very clear on that. So it's just to sort of put that into the picture a little bit.
Okay, sorry, apologies. Are you content enough, Brian?
Yes, it's a matter of return to.
Okay.
Carry on for now.
I've got Patsy.
Just 2 or 3 wee things. First of all, did you say earlier there, or did your affair make reference to a right to beg?
A right to beg. Yes, at the moment we have a ban on begging. Whether or not that it's approached by under Section 3, it's an all right ban to beg. And the police deal with it in a proportionate way currently under Section 3. So they would engage with the person and they would only arrest.
Sorry, what I meant was, did I pick you up right or wrong? Did you refer to there being a right to beg?
Right to beg? In terms of what context?
As in having a right to beg?
No, it's protections in the judicial review, the JR that was brought, that there are protections around persons begging.
No, I get where you're going there about the human rights stuff, but that doesn't qualify as a right to beg, a legal right to beg.
That there is a person shouldn't be disadvantaged in law.
No, there's a we're talking two different things there. Person being disadvantaged, the human rights being abused or whatever, and having a legal right to do what they're doing. may well be two different things. I just want to get that clarified in my mind. A person being disadvantaged under human rights legislation is one thing. A person doing something which legally isn't right is another thing.
Under our current legislation, Section 3, it is not lawful to beg.
Right.
So
well,
we are
okay.
decriminalising that.
Well, that's all I want to clarify.
Yeah.
Now, the second thing was then, please, and I hear where you're coming from, understand where you're coming from, but in some instances, there is a distinction. I've heard what you're saying about there being, I'm not sure it's 100% correlation between begging and addiction. There may well be other mental health issues and stuff.
Yes.
But in those instances where the begging is done aggressively, what's the option then? Aggressively so, as in really aggressively so?
If that's really aggressive, it very much depends on the circumstances. But what we're saying is where a person, and like any other member of the public, if they were to cross that criminal threshold, if they're harassing, there is harassment legislation, etc. So what's the aggressive nature? Are they harassing the person? If that's the case, then that's a criminal offence. So this is about what we're trying to say is we need to take the begging behaviour out of the whole thing and treat this in the same way as you treat another member of the public. So if someone is being aggressive to you, there are means and ways when the police can deal with that. If they attend, they can talk to the person and talk that down. That's always the first approach to anyone. And if it is a person with complex needs, which these people mainly are, then that's about making sure they get the most appropriate support.
Okay.
But there is an existing criminal offence under the Protection from Stalking Act of a person acting in a threatening or abusive manner, which is a single instant offence. So that's a criminal offence which exists.
Do you know
in
offhand
statute.
have there been many people prosecuted under that? You don't know?
That's a new one, and it's one that we listed in our consultation. And the police have said that, and if I understood ACC McNally last week on that, he said, that there are other offences there that can deal with these behaviours. And if you're looking at, you have to look at what gap you're trying to plug. We don't believe there is a gap with repeal. And Professor Brown's amendment, we believe, would be a step backwards. We certainly would be backwards on our step in terms of the wider UK. And also there would be particular issues around application. There's potential for, in our view, for a challenge for Clause 1 particularly if it's not applied properly. And I think if we're changing mindsets, and I know the police on repeal will be looking to do that, it's not a case of, that person's begging, you can do them under vagrancy. That's not what we want to change the mindset so that we're saying, look, if this person we need to look at the tools that we already have and deal with that. That's how Scotland deal with it. And Scotland, there has been a couple of attempts by, I think it's at Glasgow and Aberdeen, where they've tried to bring in bylaws to deal with nuisance begging, etc., that sort of thing. And the Scottish Government has been very clear that it will not support that because they have the authority on that in terms of whether or not they should allow them. And they're not going down that route either. And Labour Government aren't going down the route. And I say Republic of Ireland's been in since 2011, the Lakatos judgment's 2021.
Okay, thank you.
Sorry,
All right.
Just revert back to the I don't know the figures off the top of my head, but we did produce a report on the operation of the Protection from Stalking Act, which was a requirement under the legislation to make a report to the committee, and that included a breakdown of offences, both the offence of stalking, use of SPOs, and the use of that offence of threatening or abusive behaviour. So that it should be on record with the committee in terms of how often that offence is. Now, that's in the current sphere. If vagrancy legislation is repealed, you may find that that's an offence that there's an uptake in, or it's something that if the police aren't able to use other means, someone who is being aggressive and is being harassing, is threatening somebody, you may find that is the gap is filled with that offence that already exists as far as the police are concerned. So.
Okay. Thank you.
Okay.
Connie?
Yeah, thank you. I was going to ask about Professor Brown's amendment, but Lorraine, I do think you've just covered it really well, and you've been quite clear that it will continue to criminalise and therefore, in the department's view, marginalise people who are homeless and begging. And I really appreciate that, and I think I don't really actually have any further questions because you've been so clear on it. And I think just to say, I think that's quite. I really appreciate how clear you have been, because I know the committee's discussed that before, and I think just to urge everybody to have compassion and caution when talking about this at times, because it's people who are vulnerable. So thank you.
Thank you. And it is important, obviously, you know, and that's why we consulted on this. Ordinarily, you wouldn't carry a consultation, a public consultation on a repeal, but this was too important, and we did that consultation, and it was really good that we did have response from Professor Brown, but in this instance we do not support.
Thank you very much.
Thanks, Connie. Okay, we have 2 more planned amendments that we were to cover. Have members got comments on any of those? I think the responses were fairly positive for both of those as outlined. If nobody has any other questions or comments.
On anything, or
Ciara, sorry.
Just one.
Just you don't want to throw it.
No, as I heard myself saying that, there was a voice in my head saying, "Shut up, Andrew, shut up."
Just one. Obviously, it's the planned amendment on serious organised crime.
Yes.
Just how, just generally, do you feel that the proposed amendments will ensure that children who have been exploited or coerced by criminal gangs are not criminalised by the proposed offences? And I know obviously you've mentioned a range of other statutory offences that a child could avail of, but is there not a better way of doing it where it's actually clear within this amendment or on the face of the bill that it's clear that they will not be criminalised?
That's actually a point that we did extensively discuss with our operational partners whenever we were drafting the clauses. We also went back to other jurisdictions very recently to check the position with all of them as well, and they've come back to confirm that children aren't excluded from their legislation. So just to be clear about that, we are very alert to, you know, the harm caused by organised crime and the seriousness of this offending, and we're just slightly concerned that if we were to exclude children, then there is the potential that they could potentially be maybe coerced or exploited into carrying out the activities by those who are directing. So what we wouldn't want to do would be create something where others are encouraging children to evade prosecution themselves. We've spoken to colleagues in PPS, and they are they're adamant that there are safeguards in place, so they would take this into consideration whenever they're building the case. There's the independent prosecutorial, can't say that word very well today, decision-making process, as well as a public interest test. So they would very much factor all of those into their considerations. There are other mechanisms coming in which may provide some additional safeguards. So colleagues, for example, are working on the child criminal exploitation offence, which may help provide safeguards, and that's coming in the Crime and Policing Bill through potentially an LCM. In addition, there are defences that would sit, such as the common law offence of duress, so that could potentially be used. There is also a statutory defence under trafficking legislation, which could be used specifically for children under 21 in specific circumstances. Again, we're working very closely with operational partners, and we're going to develop guidance and make sure that there is robust reference to this to make sure there's a consistency of approach in all cases. And it's something that we do want to engage with not only our operational partners, but some of the wider voluntary community sector, to make sure that whenever the guidance is being developed, that it's reflective and there are protections in place for children. Whenever the definition of the links to the offence was being created as well, we discussed this, and that's one of the reasons why we have it linked to an offence of 4 years or more, and that's so children won't get caught up for low-level offending, because it has to link in through that. So it's something we're very mindful of. We'll build on it and we'll look at it again whenever we're developing the guidance. But we wouldn't want to put anything in place that could potentially then act as a loophole where children could be exploited in another way, you know, with the unintended consequences. So.
Oh, thank you. That's really, really satisfying to hear. I do fully understand the unintended consequences, which could make things worse. And I really appreciate the guidance aspect of it, because although there's a range of other options and get quite messy, they navigate once go through the loophole. So I think the ideal is having guidance around it, so there is a consistency of approach. So thank you.
It's something that our operational partners are very keen on, because we want to ensure there's consistency of approach as well. So hopefully that will negate that, and we'll keep the committee informed as we develop that.
Okay.
Okay, yeah, brilliant, thank you. I think at that point that can conclude that session, and we can move on and let you go. I suppose just for clarity, the next item that we have here is a raised paper just about that legal aid, that taxing amendment that I was talking about earlier.
Yes, it's a paper that we haven't yet seen. So I guess that we will take receipt of it from you. I'll alert policy leads to the fact that it is coming. We'll get you a detailed written response. And of course, the committee might agree then that we ask for a further presentation on that. I was going to say those officials can be made available at your soonest opportunity. I was completely confused there. Oh, well, I was like, am I don't here? You were obviously working to an agenda that I was unsighted on, but I would say, Chair, we'll leave on a high note, which is lovely, and thanks to Debbie. To follow up, we'll send you back the completed table with the outstanding issues addressed. And the action point that I'll also take away is to share the amended draft of the Access NI clause with the change to the that wasn't the amendment I was talking about. I got completely confused there. It was this. So thank you very much. Appreciate your consideration of all those issues. Brilliant. Thank you. So members, if you're content to move on to the next agenda item, which is just consideration of this raised written paper. So obviously this was referring to a proposed amendment from the department that we haven't had sight of yet. So I would suggest that we forward that to the department as just outlined, if everyone is content, and also request clarity from the department around whether or not the human rights organisations have been consulted in terms of this amendment that we haven't seen yet, if everyone's content that we do that. Yeah. Okay. Then we are agenda item 7, our written papers. Page 241 of the meeting pack, we have a response from the department around the scrutiny points that were highlighted on the Assembly raised paper on the proposed live links amendments to the Justice Bill. Are members content to note, or if there are any further actions, people can come in now, yeah. Then 7.2, we have a response from the department regarding sort of responsibility to Article 2 Windsor Framework. And I note that in that response it highlights that the Human Rights Commission didn't provide any sort of substantive comments around this. If the committee are happy, I would suggest that we go back to the department and ask for an outline of the commentary that came from the Human Rights Commission. Just I know that they have said that their solicitor is sort of content that it's compliant with Windsor Framework, but obviously that's a significant piece of work. So if everyone's content, can we do that? Yeah.
We're actually we want a copy of the Human Rights Commission's response. Yeah, thank you.
Happy enough. Yeah. Then we have got at page 246 to 248. We have responses from CRJ and alternatives relating to the restorative justice element. Is everyone happy to note that, or are there any actions that anyone wants to take forward there? Happy enough?
It's quite, there's a range of, obviously, clarities around their response. Could I go through maybe a few of them, if you can allow me? It's just obviously the page 3, gap 1, there was the inadequacy of level 1 accreditation. CRG noted, and alternatives noted, they were disappointed in the Department of Justice response, which stated they envisaged they'd have a level 1 accredited practitioner associated with their organisations, despite the fact that they've been operating over 30 years. So it's, to me, that's quite concerning. Just the significance that is given to organisations that have been providing restorative justice for, well, they had 60 years in total, and they see them, both organisations, to be applicable to do a level 1. So that's one thing. I think it's to note that they have raised that, and likewise CRGA and NI Alternatives had argued, and it was number 2, gap 2, page 5 of the report, that the framework is not locally relevant or significant due to local knowledge and expertise being lost throughout the development of this policy. They seem to totally have relied on the British Restorative Justice Council, who do not operate here in the north, do not have one staff member that operate here in the north, and they have been cited 8 times in the guidance on this, and never once has community restorative justice or alternatives NI been mentioned, and they've been practicing here for 30 plus years. So once again, I just find that not acceptable, to be honest.
Do you want to forward that feedback to the department?
Very much so, and I would like them to address the key issues that they have highlighted.
Are members content that we do that as committee? The department with that? Okay, and then we have a response from the Simon community. Are members content to note that as well?
Noted.
Yeah? Okay, let me see, what is the... Okay, then we have a response from the department relating to the evidence that was provided by Professor Brown and his proposals for an amendment to cover the begging, causing harassment, obstruction or public order. So obviously we've just had a conversation about that as well with the departmental officials. Are members content to note that response in the department? Yeah, happy days. Then item 7.6 of the table papers, 15 to 27 of the table pack, which is the department's response providing information on legal aid fraud and error, a breakdown of legal aid expenditure, an update on the publication of the list of legal aid payments, and further information on a number of taxation matters. Are members content to note the department's response on that? Yeah. Okay. Then we have got statutory rules. So if we bring these forward. Okay. They're separate but related. So these are statutory rules proposed by the Department of Justice. A single memo covers both of these SL1s at pages 266 to 269 of the meeting pack. Each will be considered as a separate item. Both of these SRs are intended to address the potential safeguarding gaps regarding the delivery of adult restorative justice initiatives and with respect to self-employed individuals whose role requires them to work with vulnerable groups. Members should be advised that there's a typographical error in the SL1 at page 270 and in the title of the draft statutory rule at page 275, and the explanatory memorandum at page 278, where the year should be 2026 rather than the 2023. So beginning at page 266 of the meeting pack, the department proposed to make a statutory rule to amend the Police Criminal Records Disclosure Regulations 2008. This SR will make provision for eligibility for enhanced access NI checks under the Police Criminal Records Disclosure Regulations 2008 Act 4, considering an applicant's suitability for becoming a practitioner for the purposes of delivery restorative justice interventions, inclusion of a check of the adults barred list for this role, and removal of the age restriction 16+ for enhanced checks for those whose home is used from provision for hosting guests under the Homes for Ukraine scheme. The rule is subject to a negative resolution procedure. It's proposed to come into operation on the 3rd of February 2026. Are members content with the proposal for an SR, or do they need any further information or clarity?
Sure. Just, you're linking 8 with 9, are you? Or are you just dealing with item 8?
This is 8 first.
Right, that's fine.
Sorry,
I have a comment
Brian,
just on number 9, but that's fine.
Just I think anyway, yeah.
Aye.
So is everybody content enough? Yeah. Okay, so then agenda item 9, SL1, the Rehabilitation of Offenders Exceptions Amendment Order 2026, and this begins at page 282 of the meeting pack. Department of Justice proposes to make a statutory rule to amend the Rehabilitation of Offenders Exceptions Order 1979. The SR will make provision for new exclusions under the Rehabilitation of Offenders Exceptions Order 1979 in respect of individuals whose suitability is being assessed for the purposes of delivering adult restorative justice interventions, individuals undertaking a self-employed personal employment role with vulnerable groups. This rule is subject to the negative resolution procedure, and it is proposed to come into operation on the 3rd of February 2026. Are members content with the proposal for a statutory rule, or do they require further clarification? Lana, right? Go ahead, Brian.
Well, I don't want to hold the thing up unnecessarily.
No,
but I'm just, it talks about spend convictions are to be disclosed. I mean, I've always thought the word was spent. You know, I've never heard with a D. So anyway, if we could just, maybe that is a legal term that's used, but I looked it up on the internet and I couldn't find spend convictions, so I've always thought it was spent with a T.
Okay, so, and we did have a wee thing about errors there, but I don't think it related to that. So
if we can just check, is that the just legally, you know, this is a matter of legislation. Anyway, that's the term I think most of us are more familiar with.
Okay.
The idea of convictions being spent when they don't need to be declared, you know.
Okay, can we ask for clarification on that? Sorry, Ciara, did you have a comment?
No, just on that as well. I have a couple of maybe questions. Obviously, safeguarding is critically important, so I get it, but I'm a bit concerned there has been no consultation on this. So I'd just like to know why there hasn't been any consultation or engagement, maybe by the department, at a minimum, maybe a targeted consultation, and know that it's those that it's impacting on. I think it would be appropriate to get a view from the Criminal Justice NI, who carry out the role of maintaining and inspecting the accredited practitioners list, and likewise from the Equality Commission or the Human Rights Commission, given that the issues of safeguarding require careful consideration. So it's just maybe there has been. Has there been any targeted consultation?
Okay, is that for 8 and 9?
No, just for number 9.
Okay. Okay, so is everybody happy if we go back to the department with that? Okay, so then we have agenda item 10, page 288, right through to page 879 of the meeting pack. Department of Justice proposes to make statutory rule under powers conferred by the Police and Criminal Evidence NI Order 1989. Known as PACE, the rule is subject to negative resolution procedure and will revise PACE codes A to H and introduce a new code I. Committee has been considering these revised PACE codes since February, which has included oral evidence from both departmental officials and the Human Rights Commission, as well as an informal meeting between the Chair, Deputy Chair and the Justice Minister. I want to remind members that at the meeting on the 20th of November, when the committee last considered these PACE codes, the committee considered a revised draft Annex L to PACE Code C, which will be replicated in Annex J to Code H and in Annex H to Code I. Members outlined the views of their respective parties and agreed to ask the Department if the guidance from the National Police Chiefs Council, NPCC, particularly the no detriment safeguard, could be more explicitly incorporated into Annex L. Concerns were also raised about whether an officer could be forced to conduct a search if another officer willing to conduct it could not be found at the required time. The Department's responses advise that no detriment safeguard is an operational matter for the PSNI, and therefore it is not possible to include this in the PACE codes. The Department has also forwarded a letter from ACC McNally to the Committee Clerk, which advises that the PSNI will adopt the NPCC guidance with effect from the 15th of December. The Department states that the PSNI has confirmed that it would not compel an officer to conduct a search if another officer willing to conduct the search cannot be found at the required time. The NPCC guidance to be adopted by the PSNI states that an officer or member of staff can refuse to search a trans detainee and there will be no detriment to them, and confirms that a lawful order cannot be given to an officer to conduct a search of a trans detainee. Are members, and I know the answer to this question before I ask it, content with revised draft Annex L to PACE Code C provided by the Department? Brian, you've indicated.
Yeah, well, just to comment on regarding the two options that were put forward last time. First of all, awaiting the Equality Commission to bring forward guidance, I think will be a very long wait. Basically, they've said they're waiting for High Court guidance within Northern Ireland, but our position is that the Supreme Court of the UK has made their ruling, and that should be followed, that when it comes to the Equality Act, that someone's sex is defined by their biological sex, and there should be those protections, in particular for female-only spaces. So that remains our positions. Regarding the option 2, I mean, we do welcome that the National Police Chief Constable's guidance has been incorporated, has been adopted by the PSNI. However, we had asked that the safeguard of no detriment to career should be specifically included in Annex L of PACE Code C. So even though, as I say, the PSNI has adopted that MPCC guidance, we do feel it would be possible, that specific protection for police officers in all sorts of situations where someone might declare and require a female officer to search a biological male or vice versa, that if officers decline that there should be no detriment to their career. So that's what we have sought throughout, and we think that can be included because the guidance in the annexes does include some practical measures about what things should be done. So to say that that's an operational matter, I mean, there are operational procedures included in the annex to the PACE codes. So we feel we would still call for that extra step to be taken to include that protection of no detriment to the career of an officer who does not wish to search a trans person in circumstances where they're not comfortable with that.
Anybody else want to make a comment? Doug, are you indicating? Yeah. Go ahead, Doug.
Just trying. Emma, do you know what? I'm looking at this and I'm thinking that the National Police Chief's interim guidance pretty much covers everything that I was concerned about. So that's what they're going to apply practically. I'm just wondering why, when they say they can't put something in because it's an operational matter, surely they can put something in to the paper which is interim guidance that the PSNI will be operating the National Police Chiefs Council's interim guidance in this. So it's referenced, and if it's just referenced, it covers the whole swathe of what I feel needs to be covered, because just looking at the exercise of powers, of police powers, it does cover it all. So I don't know why the code can't have interim guidance which states exactly that the PSNI will be using the National Police Chiefs Council's interim guidance. Does that make sense?
Mm-hmm. So I suppose both of you have outlined that view. Is there an option at this stage? There was previously an option to request further advice from the Equality Commission, and that's we're still waiting on that.
Well, I've already expressed a view on that. I mean, the Equality Commission, I mean, I'd met with them as a member of another committee, and it's clear to me that they're waiting for someone to take a legal case, and they're waiting for the High Court in Northern Ireland to look into the matter. So I don't see any prospect of them actually bringing back a definitive position themselves. I would agree with Doug that even if the annex could make reference to the MPCC guidance, this is we are just pushing this because we want to see officers not put in a position that they're not comfortable with, and that there would be a detriment to their career. And I just think there could be scenarios where you have like fellas who are out and in a situation where they end up that the police are engaging with them because of concerns about criminal activity, and they start to declare, well, I'm a biological female, I want to be searched by a female officer. Situations like that there, that the police officers need to be protected. So I think we're very close to the situation. If we're told that the PSNI as a body is going to adopt those guidelines, why not have that referenced in the actual wording of the annex?
Yeah, I wasn't sure if that's what, if you were indicating that you wanted to come in there.
That's why I stayed on, just in case there was anything. To try and just explain again, I think we tried to set it out in the letter, but apologies if that wasn't clear enough. The Codes of Practice, Code C, deals with the detention and treatment of persons in custody. So the legislative scope of the codes is around the treatment of people being held in custody. It's not about officers. I think there's an introductory note. This is off the top of my head because I don't have a copy of it with me, but I think there's an introductory paragraph to Annex L which says that the role of the department is to put the codes in place, and it's for the Chief Constable to put guidance in place relating to officers. So we can't prescribe, we can't tell the Chief Constable what guidance to put in place, but we've said that it's his role to put the guidance in place. So the letter from ACC McNally explains the guidance they put in place, which is the NPCC guidance. Sorry, too many C's. And obviously the NPCC guidance sets out all those particular protections around officers and the fact that they wouldn't be compelled to search a trans person, and there wouldn't be any detriment if they refused to do that. And you'll also see from the wording of Annex L that we do provide for that situation that you talk about, that somebody can't just, a man can't just walk into a police station and say, oh, just on this very moment that I'm a woman. There is a particular process to work through to see if there is that issue around dealing with doubts and dealing with cases where the person is trying it on, for want of a better word. Those sorts of issues have been worked through in the wording of Annex L to try and address those concerns. So to say we can't, there isn't the legislative scope within the code to deal with officers. That's the role of the Chief Constable. We've said that it's his role to put that guidance in place, and obviously the PSNI have now written to you to explain the guidance that they've put in place and that they will be following the NPCC guidance, and there wouldn't be any detriment to an officer who didn't want to take part in a search. And that is, we've tried to go as far as we can, and that's as far as we can in terms of the remit of the codes.
Yeah. But if that, through the Chair, if the decision to adopt the code has been made by the PSNI, I don't see why reference to it cannot be made.
We wouldn't make the reference. We wouldn't make the reference maybe in the body of the codes, but we can make that reference in documentation published alongside the codes. Is that of any use?
Yeah. We're so close to agreement on this.
I appreciate that, and we're really keen to get agreement to this, but it wouldn't be appropriate to put it in the body of the code, but we could put that as an explanatory note that whenever we're publishing the code to explain that. Because we could explain the issues around why there's an interim position on Annex L, and we can explain in that in a guidance to publish with the codes to say that this is an interim measure in relation to Annex C, in relation to where we're waiting on the outcome of the Equality Commission's legal challenge. The PSNI has decided to implement the NPCC guidance.
Yeah. Well, just, I would propose that we write again, just saying that, given that the PSNI is adopting the NPCC guidance, that I would like that put in writing back to the department, that be mentioned in Annex L, and I think that will resolve the matter.
The premise that you've provided in terms of the risk there doesn't really make sense.
Well, it does, because it then addresses the gap that we feel is there.
Well, if this
officers will
to
still feel it'll be held against them.
If this was to deem that someone had to be searched based on their biological sex.
Well, it's done in consultation with the and it goes into quite a lot of detail. In fairness, there are various scenarios and consents, but we feel that is the gap that needs to be, that officers shouldn't feel compelled or that it'll be held against them.
Well, I've got Doug come back, and then Ciara, then Connie.
Yeah, very briefly, Chair, if I can. Look, I also think we're really close here. I just cannot understand why this couldn't be a footnote to the Annex L. Just a simple footnote. So it's just reference. So it sits on the foot. It's not part of the document. It's a simple footnote, and therefore, because we pass this as legislation, that everybody feels covered by that. So a simple footnote would cover this whole thing. I can't understand why we can't do that when throughout the whole document there are so many references to operational procedures that are carried out. But a simple footnote would kill this off now.
And from my understanding of it, it's because it hasn't been tested by the Quality Commission, so we're waiting guidance.
And then Emma, if we apply that, then there's no protections. If we're saying we're waiting for the Equality Commission, then we have to go back to option 1, wait for the Quality Commission. That'll be a long wait. So I guess that's the problem that we have.
What I'm suggesting is instead of, it wouldn't be a footnote, but it would be a cover or a guidance note that we would publish alongside the code. It wouldn't be included in Annex L, but it would be published as alongside the code.
Okay, but
sorry,
go
ahead,
I jump in? Sorry. Okay, but if you do that alongside it, what weight does that carry? I know we look at bills and we always want something on the face of the bill because it gives it the full protection. What would an explanatory note that goes along with this protection would it actually give if challenged? But if it's on as a footnote, it gives the full protections. You know what I mean by footnote, don't you?
No, I know what you mean, and I'm just trying to think.
There's no
obviously a guidance note wouldn't have the same effect as a statutory part of the code. But what I'm saying is we can't put something in this. We can't put anything into the code because it's not within the remit of the code.
And I'm afraid that's what I don't quite understand, because what the code does reflects practice, and on an interim basis, the practice is going to be as per the NPCC interim guidance. So it actually is reflective of practice. So this is why I don't understand, and it's a little bit frustrating for me, and I know it's really frustrating for you, and I want to get this across the line, and that's why I'm looking for a solution. And the footnote is just gives me practice during the
but what I'm saying is
period.
It wouldn't be a footnote. We could publish something alongside the footnote as a departmental note.
Okay, I don't think we have to make a decision on this today, Ciara.
And I just need to reiterate, I don't think no one individual, whether it's a chief constable, whoever it is, should be tasked with deciding on a rights issue, to be honest. And it's just reinforcing the fact that we should be waiting for the Equality Commission guidance on this. And that's...
You think we should be waiting?
Yes.
And how long do you think that will take?
When you're looking at rights, it's everyone's rights. And it's not some rights over other rights. That is the bottom line on this, and that would be my position.
The issue we have, well, there's two things. Obviously, the Equality Commission has applied for leave to seek a declaration from the court on the impact of the Supreme Court ruling here. So that process can take some time. By the time it would get through the courts, and they would develop and consult and guidance, and then we would have to consider that guidance and see what, if any changes are needed in light of that. So that's all going to take some time to work through. And the other pressing issue that we have is that we need to get the code updates in place, because we need to update the codes to reflect the changes to, and I know that you have your own objections to this, but we have to ensure that the proper safeguards are in place to reflect the changes to the counter-terror legislation and the National Security Act. So we need to put the new Code I in place. And we've all...
that Code Hitchin is totally draconian legislation.
I
don't agree with them either. They're a breach of citizens' human rights. So
I appreciate that you have objections to those, those and they are reserved and accepted matters, but we need to make sure the department has a duty to publish the codes and to update the codes to take account of that legislation, and to make sure that those safeguards are appropriate and up to date for anybody held under Counter-Terror or National Security Act. So we have it, and obviously the PSNI are also keen to make sure that they have the updated codes in place for them in operating those powers, and to ensure that those protections are in place for individuals who are held under that legislation.
I do understand the position that you're in.
Right, Ciara Connolly.
Yeah, I'm obviously happy with the department's approach on this, and I'm happy to proceed. I don't think there's much point in writing to the department when we have the relevant official in front of us, and the points that we're making are going to the relevant official who's answering them. So I don't really see the point of then writing to the department again. I would be extremely shocked if there was something different came back than what Lisa is telling us. I do have some concerns, obviously, around the risk this not doing this puts the department at. I think from the memo we have here, the first time we discussed this as a committee was February. It has been a significant amount of time. And the reading I have, I'm very content that the PSNI have explicitly stated that they'll be following the MPCC guidance and never impose a career detriment on an officer. And I think the solution around publishing a document from the department alongside the codes, I would support as well, as a way to try and bring consensus on this.
Thanks. I suppose I would have reservations around even how that's worded and framed, and notwithstanding you all have been at this committee for a lot longer than I am, but the risk of detriment to an officer is, in my view, how it's presented here is placed, there's greater importance placed on that than the risk to a trans person who's already somebody that's in a minority in the north of Ireland and has already had their rights attacked on a number of fronts. So I suppose I'm not completely comfortable with that, to be honest with you. But it is what it is until we get Equality Commission guidance. I don't know what way that leaves us in terms of how the department proceeds.
It's for the committee to make a decision about what it wishes to do next.
Well, I would propose that we write to the department asking that they incorporate into the annex the word, either a reference to the MPCC guidance or that they include specifically that there will be no career detriment to an officer or member of staff who refuses to search a trans detainee.
Are you proposing that we put that to a vote?
Yes.
Okay, we can take a vote on Brian's proposal. All those in favour? Okay. And all those opposed to that?
Opposed.
Can I just say, like, I don't really see the point. It's not like, it's not that I'm against going or writing to the department. I just think Lisa's literally told us the answer to that, and we've got it now. We've got it in writing. It'll be minuted. I just think that's just going to delay things. So it's not any other opposition of writing to the department for further clarification. It's just we've literally heard the answer from Lisa.
Okay, so if
the reason is because this is about wording, you know, and that's what we're trying to get to, wording that, and I don't think we're very far away from it. Although it sounds like Sinn Féin are saying they're not going to back anything until the Equality Commission, which is going to be months, maybe years away.
So Lisa's, I suppose, provided us with the rationale or the practicalities around this, and her solution or proposed workaround in the interim. Are you happy to allow that to proceed? You've noted that you're...
Well, we're not. I'm not consenting to adopt the annex, if that's what you're, the wording in the annex.
Okay. Doug, go ahead.
Yeah, Chair, I mean, look, if I'm really honest, I was hoping to get a solution so that we could do something now, and that's why I mentioned the footnote so that we could get it. But if the consensus is wait to the Equality Commission, that actually suits me just fine as well, because that means the officers will not be put in a difficult position. You know, I would rather have had a solution, because I know it's desperate to get something across the table here. But if we have to wait, then we have to wait, and that's just the way it is.
Okay. So can we? So are members content with revised draft Annex L to Pace Code C provided by the department?
No.
No. Okay.
I don't think you're content either.
There's endorsing something, and then there's actively objecting to it. So where does that leave us then? If members are not content with that, this just...
I think if members aren't content with it, they're clearly not content then to agree the proposal for the SL1 today. And having then decided against writing to the department again to suggest that EPC or the MPCC guidance is incorporated, then I think the committee does need to decide now, because that's sort of the two. So you need to decide what you want to do next.
And one of our options there can be that we wait for guidance from the.
One of the options is a formal agreement to wait.
Although we haven't agreed anything basically at the moment.
No.
So
No, you've agreed
that's our
not to
position.
agree, yes.
So there's been no agreement to anything. So the matter just sits then.
Okay.
I suppose yes. It's what you want to convey to the department through Lisa on that as to what the next steps are. Is it to wait for the Equality Commission, or is it because you're not writing to the department on the issues? So what are the next steps then? Does it just sit for that length of time? Is that a decision that the committee is making then, really?
Well, it's up to someone to make a proposal. I made a proposal and it was voted down.
So are members content to wait then until we get Equality Commission guidance on this?
Or is there any other proposals?
Would it help if we shared a draft of a note that the department would propose to publish alongside the code? If we come back to you and say, if the committee agrees to the code and to the revised annex, this would be the note that we would publish alongside them and set out some text.
Sorry, Doug, did you?
Yeah, sorry, I think, look, we're all trying to work around here. I think it's only fair. I mean, I've laid out what I think a footnote would have been great on the PACE codes themselves, but if the department wants to come back and show us how they want to incorporate it in a different way, I think we need to give them the opportunity to do that. So I wouldn't have an issue with that.
Okay, so we'll get the department to come back with that clarification and we'll make a decision then. Sorry, Lisa, thank you very much.
Thank you.
Okay, do we have to deal with the rest of the PACE codes at that point? We just leave them there, okay. And then we've got correspondence, memo.
Sorry, just to be clear, when the committee's agreeing the proposal for the SL1, it's agreeing all of the PACE codes, not just the Annex L. Okay. So you will be agreeing.
We're opposed to them the last two, maybe. So. Okay, so we've got the committee, or the correspondence item, apologies. Are members content to note these items of correspondence?
You can go through them. I'm going to go through them.
Beginning with 11.1, 11.2. Oh, sorry. We've got 11.2. Are people content to note these? People can input if there's a particular correspondence item that they have an action point for.
There's just one I have.
Yeah, go ahead, Karen.
11.9, the House of Lords and Scrutiny Committee. Could we ask the Scrutiny Committee for a copy of the letter sent from the Minister of State?
Happy to do that. Yeah, everyone can help with that.
Chair, just to say there are actions set out. I think that was one of the actions set out in the memo. Yeah. And there's the table pack that was issued yesterday had suggested actions set out in the memo too. So I suppose the question is if members are content to action.
Yes. Yeah.
Those as set out. Yep. I think Doug has indicated.
Oh, sorry,
he wants
Doug.
to come in and something too.
It's okay. No, don't worry. There's lots coming in at you, I'm afraid. Are we dealing with the table pack correspondence, Emma? Is that okay?
Yes. Yeah.
So sorry, I'm just it's 11.3 in the table pack, and it's a responses to stuff we raised with the permanent secretary when he was here, and he's clarified the regulations that they're using for pre-release testing, and I'm not content with that because basically they're saying that Rule 27 of the Prisons Young Offenders Centre Rules 1995 is the authority for them to allow people to be who's life prisoners to be relied out for day release. Yet Article 6 of the Life Sentence Order, which is primary legislation, clearly states you're not allowed out until you've completed your mandatory tariff. So one doesn't work against the other. And the former of what I just said, that Rule 27, is secondary legislation, not primary. So I think there's a conflict here that the prison service are allowing people out on day release as part of pre-release testing, life prisoners, when they shouldn't be because Article 6 prevents them from being released. So I wouldn't mind some more clarification on that, and I'm not sure if that needs somebody to come in and answer some questions. I hope that makes sense, Chair. Apologies if it doesn't.
Okay, so you want to go back to them on that, Doug?
Absolutely, Emma. It doesn't match up to me that they're allowing secondary legislation to trump primary legislation here, and it's quite clearly laid out on the paperwork that they sent us that life sentence prisoners cannot be released from custody until they have finished their tariff. But at the minute they are, and it's 3 years before they've completed their tariff, they're being released on day release, and I don't believe that's correct. So I would like to know how they've come up with this decision.
Okay, so we can write to them and ask further clarification on that. Happy enough?
I'm sure the clerk understands what I'm saying.
Yeah, yeah, I've got it. I've checked out the stage. So then the last item here is our forward work programme.
Sorry, Chair.
Bronarm, sorry.
Sorry, just before we move on, I just want to comment there. There's a reply there about the jury sustenance provision. So, I mean, I asked that following a media article. So note there it says in 1114, given the unpredictable nature of a reply from the department, from the Justice Minister, given the unpredictable nature of court business, previous arrangements often resulted in significant amounts of food having to be discarded. Current arrangement by which jurors are provided with tea and coffee making facilities and claim a meal allowance reduces the amount of food waste. So there is an allowance provided for lunch if jurors are on duty. So anyway, it's just to note that there is provision for them. Unfortunately, it's not actual food, but I suppose maybe in the past food has been brought in, and you never know when a court a trial is going to proceed or not. So I could imagine previously there was a lot of food going to waste, and I'd like to think also that there are, whether there's canteen facilities, in courts or not, available to them. But anyway, just to note that at least a meal allowance is provided for jurors, along with tea and coffee making.
You're content with that, Brian?
Well, at least there is some provision.
Okay.
As I presume it's in monetary terms. Maybe it has to be claimed afterwards. But anyway, at least there is some provision along with tea and coffee.
Okay. Okay, so our next agenda item is our forward work programme. Are people content to note that? We have a number of meetings there, and people will notice that we had previously requested a meeting with the Lady Chief Justice, and she has confirmed her availability to meet with us on the 22nd of January to discuss delays in the criminal justice system and the taxation process. So potentially that's going to happen with her, alternatively here, so we'll get confirmation of that later. Are members content with the forward work programme as outlined? Okay, so so are members content to agree the department's forward work programme for January at page 147 in the table pack, which has amendments to it? Yeah.
Mm-hmm.
Okay. There's no chairperson's business this week. Has anybody got any other business at agenda item 14? No. So the next meeting will be in the new year, Thursday the 15th of January 2025 or 26 at 2 p.m, room 30, Parliament Buildings. Thanks everybody, and have a nice happy Christmas.
Committee room 30, sound. 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 Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound. Committee Room 30. Sound.